For judgment, item 1.
Writ petition has been dismissed. We have given our reasons.
May it please your lordship.
Yes,
Madam, may I pray for listing of the matter on Monday motion?
sorry,
Motion matter on Monday.
what is the matter?
My lord, there was an allegation of sexual misconduct on my part against a female employee. The internal committee examined the matter. Ultimately, conclusion was reached. There was no evidence. The matter was closed. Subsequently, in the wordings of the committee, the lady had a problem. She filed a complaint again to change the word, not against the company. Taking a cue from that, my service authorities have initiated a disciplinary proceeding against me. Under the act, when the conciliation is and the matter is closed, there is no scope for reopening it. Filed as a DP member. Now I'm called it Kolkata. I'm posted at Patna. The incident in Guwahati. To the next 2 year filing urgently. I'm not playing to Monday.
Wednesday.
My lord, 22nd, 21st. The
They
Tuesday. is the-
will finalize the proceeding.
Well, my father died this morning. Gentleman had come to and affidavit he just left. My lord. These difficulties come so that I can at least place on record something. May I pray?
No, what will happen if it is taken up on Wednesday?
Nothing, but they might take an adverse call. That
What is that call? Tell me something.
absence, non-participation, that might ensue.
No, when is the date fixed
21st, Tuesday, in Kolkata
for appearance?
for appearance and for personal hearing. In that circumstances.
May I please, your lordship. Lordship, I beg to mention, pray for a listing of a matter in name. This matter is pertains to 2020 regarding his pensionary benefits have been withheld due to dismissal from service. The charges are identical with 2 other officers and they have been given a very less punishment. So any day or next week or day after.
Any day after 16th of March, you put your date.
Lordship,
Yes, after 16th of March.
May I
Yes,
please, your lordship, lordship, with the consent of the, I beg to mention item number 14, lordship. The consent of the other party kindly adjourn the matter for the day.
item number 14.
14, lordship.
You are for whom?
Mr. Chi Sodris, lordship.
On the prayer of learned counsel for the petitioner, admission hearing of this matter stands adjourned for 4 weeks. Yes.
May I please check? My lord, I beg to mention this matter for listing matter, admission matter. My lord, in this case, I have been appointed, but my salary is not discharged due to want of verification. Police did not verify properly, my lord. So I have filed this case. They have filed affidavit, my lord. So any date in next week.
Any date after 16th March. Yes. Choice is yours. You fix the date. This court is now allowing the councils to fix the date. What more can you ask for?
Actually,
Can you ask for anything more? Any date after 16th of March. Yes.
May I please, your lordship, lordship, I beg to mention for listing of a matter pertains to compassionate appointment, lordship.
When do you want it? You have heard it?
Yes. Highly honorable. May I pray, your lordship, I beg to mention item number 45
45.
for the adjournment, as my senior is having some difficulty.
So senior has difficulty, you are there. This has been listed for orders. You be there, we'll see. Well, when the matter is called up, we'll see. What order is required, we'll see. All right. If it is required to be adjourned, we'll adjourn it. Don't be nervous. You go through the file and be present. All right.
Obliged, ma'am.
For motion, item 2.
May it please your lordship.
Yes.
Lordship, on 25/1/22, my lord, this court directed the petitioner to obtain some instruction, my lord, about the DLC meeting has been held or not, my lord. The DLC meeting, my lord, has not been held yet, my lord. So, my lord,
DLC meeting has not been
no,
held.
my lord.
Then,
For COVID, my lord,
huh?
for COVID, my lord, I think.
All right. So then what can be done here? Where is the contempt?
So, my lord,
The court directed if the DLC meeting is held, then your case is to be considered.
yes, ma'am.
The court never said hold a DLC meeting within 3 months. Then where is the contempt
But
here?
period of filing a contempt will be over, my lord. If you want filing in time,
No, no, it will not be over.
my lord,
These things are not examined mechanically.
yes, ma'am.
When the DLC meeting is held and if your case is not considered as per court order, that is the day you will have the cause of action. Today you don't have any cause of action.
So,
You
my
come
lord,
as and when the DLC meeting is held, if you are aggrieved, then you come.
so my lord, a direction may be given as
No,
and when the
Contempt case,
DLC.
no direction. Heard Mr. S. Upadhyay and counsel for the petitioner. By the order dated 12/3/2021, this court had directed the DLC to consider the case of the petitioner in its next meeting. However, since no such consideration was made, this contempt case has been filed, alleging willful disobedience of the order dated 12/3/2021 passed by this court. Full stop. In terms of the order dated 25/1/2022 passed in this proceeding, the petitioner's counsel has obtained instruction and submits that since 12/3/2021, no meeting of the DLC of which district is this?
District is Karbi Anglong, my lord.
District DLC of Karbi Anglong district has been held, and the apparent reason is due to outbreak of the COVID pandemic. Full stop. If that be so, it cannot be said that there has been willful violation of the order of this court. Full stop. If the DLC meeting is held and the petitioner's case is not considered in the light of the order dated 12/3/2021, it is at that stage that the petitioner would have the right to approach this court by filing a contempt case. Full stop. Therefore, by giving him the liberty to approach this court by filing appropriate petition as and when the occasion arises, this contempt case stands closed for now.
I'm highly obliged, my lord.
Item 3 and 4.
May please, your lordship. Lordship, matter related to selection and appointment, madam. The last of the occasion, madam, the respondent officer said take a time to file an opinion and opposition affidavit, madam.
No, Lordship, but item number 3, Lordship, notice is issued, Lordship.
The item 4, madam.
And item 4, notice is issued on 23rd of 11/2022. In that case, I have not yet received the instructions. Lordship, may issue notice this case also. I will obtain instructions, Lordship.
Now, what is your grievance here in item 3?
Grievance, madam, there is a selection process, madam. Written examination already award, madam. In the written examination, there is my lord, you kindly come to the page 17, my lord. There is some anomalies, my lord. A single roll number has been found twice or thrice, my lord.
So what does it mean to you?
My lord, I am also I'm also sitting the examination. And next, my lord, part, my lord, if there is a only,
Yes.
my lord,
What will happen if the roll number is corrected? You will get appointed.
no, my lord, selection, my lord.
You will get selected.
Will get selected. my
How do you know that? Somebody has told you that.
lord. Next selection name is my dear, my lord. Next selection place, my lord.
Next name is yours.
Yes, my lord.
All right, let them obtain instruction and file affidavit. Take down heard Mr. F.A.S. and married counsel for the petitioner. Alleging anomalies in the selection process conducted by the respondents for filling up the posts of accountant assistant, accountants assistant. What are the posts? Accounts assistant.
Yes, my lord. account assistant, cashier,
Account assistant,
stenographer, driver.
LDA, storekeeper come clerk, record keeper come clerk, and coding clerk. The instant writ petition has been filed entirely alleging that if the anomalies are corrected, then the petitioner would come within the ambit of the selected candidates. Full stop. Ms. A. Bora, Ms. D. Bora, Learned Standing Council, Health and Family Welfare Department, Assam, raised for some time to issue instruction to obtain instruction. Notice of motion returnable in 4 weeks. Since Ms. Bora has appeared and accepted notice on behalf of
All the
all
respondents.
the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental council, requisite in numbers so as to enable her to obtain instruction. Let this matter be listed again after 4 weeks along with item 4. And in item 4, you write list along with item 3.
Plus one.
Item 5.
Wait, Mr. Lordship.
Yes.
Lordship, in this case, I have been instructed to seek some time. They want to file detailed affidavit. Lordship, you should notice at this stage, fixing a short date after 3 weeks, Lordship.
No, first let me understand what is the matter.
My lordship, matter is simple, my lordship. Earlier, the petitioner applied for the post of general duty. Already they have qualified.
Hmm.
And similar situated candidate already filed a writ petition. And same has been disposed of 39/2022. And they are already appointed. We back before this honorable court after 3 months. So similar direction may be given.
No, but what is your case? What similar direction? You are not even telling what is the case.
Lordship, his case is that some person obtaining lesser mark than him that has been appointed. That is his allegation. Lordship. So his select list of 21, no, 2021, he approached in 23. So Lordship, after 2 years. Let us find a detailed affidavit, Lordship. You should notice fixing a short date, Lordship.
Yes.
After
Your
3
name,
weeks.
please.
My lordship, N. Islam. My lordship, kindly turn over the page 105.
He's taking a chance. He's come. He's a smart man. No?
105.
He knows what you will say. So let him have his day. Heard Mr. N. Islam and considering for the writ petitioner. The petitioners have alleged that persons securing lesser marks than them have been appointed in the post of constable (general duty) under the various
CPF, that is Central Armed Police Forces,
Under the-
CPF, Lordship.
Central Armed Police Forces by ignoring their candidature. Full stop. According to Mr. Islam, similarly situated candidates, on having approached this court by filing similar writ petitions, had got relief, and the petitioner's case also therefore merits consideration in similar lines. Mr. B. Chakravarti, learned CGC, appearing for the respondent, prays for 2 weeks' time.
3 weeks, Lordship.
3 weeks' time to obtain instruction and file affidavit. Full stop. Prayer allowed. Issue notice of motion returnable on 13th of March 2023. Since Mr. Chakravarti has appeared and accepted notice for all the respondents, no formal notice is required. to
Extra
be
copy
sent.
may be sent.
Extra copies of the writ petition requisite in numbers shall be furnished to the learned CGC within 3 days from today, so as to enable him to obtain instruction and file affidavit. The affidavit on behalf of the departmental authorities be brought on record on or before 9th of March 2023 by serving advance copy upon the petitioner's counsel. You wait, let them file the affidavit.
Obliged.
Item 6.
May it please your lordship, on last occasion, this honorable court has directed us to take instruction. Though I have not received any written instruction, lordship, but I have received the verbal instruction from the office of the CDPO Hosai, my lord. The petitioner did not submit any application for the post, lordship. The advertisement issued on 18/11/2022, but the petitioner did not submit any application.
My lord, I categorically stated in my lord, I approached them, my lord, but that did not receive the phone.
When did you approve? Where is the statement? Let us see.
My lord, the lordship may kindly pay para fee, my lord, of my repetition.
Hmm. No, but when did you submit the application? That date
My
is not
lord,
there.
it was fixed on, my lord, 25/11/2022. My lord,
What was the last date for submission of application?
25/11/2022, my lord. On that day also I approached my lord,
Hmm.
as I have instructed my lord. But they did not receive
So
because
25/11/22, you, according to you, you submitted application. They did not receive,
yes, my lord.
but you kept waiting for what? You came to the court in 2023.
Lordship.
That is at least more than 1.5 months after the. What were you waiting for?
My lord, I approached the authority, my lord.
Hmm.
Lordship may kindly see, my lord,
No, but date of application is over. You cannot be permitted to apply.
lordship.
That is over. And if so, no relief can be granted to you.
I approached the authority, my lord.
Maybe, but
they
then
have-
there is no court order. The last date of submission of application is over,
Lordship.
is it not? You approached the authority did not accept your claim. What can be done now?
But they
Now-
stated that my lord,
Huh?
my name has not been in survey.
No, that's not the point. Point is, today you cannot be permitted to take part in the selection process. That's the law. Then why should we entertain this writ petition?
My lord, that's why
Yes.
I
Heard
approached
Mr.
the,
G would be learned counsel for the writ petitioner. Also heard Ms. M D Bora, learned standing counsel, learned government advocate Assam, appearing for the
All the
state,
respondent, ma'am.
huh?
all the-
Appearing for the respondents. First of, the writ petitioner hearing has approached this court by filing the instant writ petition, alleging that her candidate, alleging that alleging anomalies in the selection process for filling up the post of Anganwadi worker in the Borhola Anganwadi Center under the Jugijan ICDS project in the district of Hojai. First up, according to the petitioner, the entire selection process has been tailor-made so as to accommodate persons of choice of the authorities without following the due process of law. First up, the advertisement notice was issued on
18/11/2022.
18/11/2022, and the last date for submission of application was on 25/11/2022.
My lord.
First up. In terms of the order dated 10/2/2023, Ms. Bora has obtained instructions and submits that the petitioner had not even applied for the post, and therefore no relief can be granted to her at this stage. Full stop. Responding to the above, no, the learned government advocate has also denied any anomaly in the selection process as alleged in the writ petition. Full stop. Responding to the above, Mr. Jiuddin submits that her client had approached the authorities with the application, but the same was not accepted. Full stop. Be that as it may, the fact of the matter is that the last date for submission of application was over on 25/11/2022. Full stop. There is no order from this court extending the date of submission of application. Full stop. The petitioner has approached this court by filing the instant writ petition only on 7th of February 2023. That is after the lapse of nearly 2 months. Full stop. Situated thus, this court is of the opinion that no relief can be granted to the petitioner in the facts and circumstances of the present case. Full stop. Under the circumstances, this writ petition is held to be devoid of any merit, and the same is accordingly closed.
My lord,
Yes.
I have authority, approached the authority that may be considered. my lord.
Nothing, authority
Because-
doesn't, authority is, the
Well-
authority cannot do it.
My lord, though they,
How can the authority accept your application after the last date?
but my lord, though they fixed the interview on 6/12/2022.
No, will not write
I'm deeply obliged, my lord.
That's not how court orders are passed.
I'm deeply
How can the
obliged.
authority accept your application after the last date?
I know, my lord, for the.
No. Yes. We are not going to create unnecessary complications. You have missed the bus this time, that's it.
I'm deeply obliged.
If you would have come before 25/11, then we could have given you some interim relief. You didn't come, you have missed the bus. Yes, next matter, please.
That is a lordship. This matter pertains to Denovo inquiry, my lord. Here the petitioner, my lord, joined as an AP constable at 10th Assam Police Battalion, my lord. Thereafter, she was transferred to Assam Police Battalion, Kahlipa in the year 2015, and now she is on temporary deputation, the Commissioner of Police, my lord. My lord, after a lapse of 15 years.
Temporary deputation as Commissioner of Police.
No, under deputation, and she is posted in the same rank at the Commissioner of Police on temporary deputation, my lord.
Posted as what?
As AB constable, my lord, as constable. My lord.
Yes.
Now, my lord, after 12 years of her appointment, my lord, a pseudonymous complaint was being lodged, internally alleging
Synonymous.
pseudonymous complaint, fictitious complaint under name.
Synonymous.
Yes, my lord. A pseudonymous complaint was being lodged, internally alleging that the certificate showing her promoted from class 8 to class 9, which was submitted in a service record, was forged and fake, my lord. Thereafter, my lord, after receipt of the complaint by the respondent number 4, that is the State Police Accountability Commission, my lord, the same was being forwarded for proper perusal, my lord. Thereafter, the commandant 4th AP Battalion Kahlipara, my lord, lodged an FIR to such effect, and a disciplinary proceeding was being brought by number 6 of 2017, my lord. After holding due process, my lord, of trial, my lord, she was the petitioner was being exonerated because the charges could not be proved. And my lord, the witnesses at that time cannot be examined because they could not be traced out. Because the complaint is pseudonymous in character, my lord. Because it is under a fictitious name of somebody named as M. Deka, my lord, who was not being traced. Thereafter, my lord, when the DP was being dropped, the order is at my lord. If my lord comes to page 44, annexure 6, this is the order. That copy, my lord, next year.
Yes.
Wherein, my lord, the DP initiated against her is dropped, subject to revival based on the outcome the criminal case registered against White Dispute PS case number 1966 of 2017 in connection with the same allegation.
So what has happened to the criminal case?
Criminal case, my lord, it has been charge sheeted. It has been charge sheeted, and at present the stage is at appearance, my lord. Now, my lord, to the effect of that complaint, which is now still pending with the State Police Accountability Commission, my lord, on recommendation of the respondent number 4, proceeding on a report, my lord. The report is that page 55, my lord, annexure 10. Basing on the report, my lord, here it has been stated that Article 20 of the Constitution of India, which gives protection in respect of conviction for offences and mandates against double jeopardy, applies to the conviction for any offences and does not apply to disciplinary proceedings, which is governed by the relevant rules. Preceding on such mandate, my lord, the said departmental proceeding was being ordered de novo and being renumbered as 1 of 2023, my lord, basing on that pseudonymous complaint. So now, my lord, the tentative action for causing such de novo inquiry without giving an opportunity to be heard, my lord, deliberately, my lord, it amounts to gross violation of principle of natural justice, my lord. And moreover, my lord, inquiry on the same set of allegations, my lord, after once being exonerated, my lord.
So what is the law regarding Denovo inquiry?
Denovo inquiry, my lord.
Yes.
Now, in terms of, my lord, rule nine of sub-rule 9 of the Assam Services and Disciplinary Appeal Rule, my lord. Disciplinary authority shall, if it is not the inquiring authority, consider the record of inquiry and record its finding on each charge. Now, my lord, coming to Manual of Departmental Proceeding, my lord, Rule 6, my lord, in terms of fresh and further inquiry, where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed and that they have caused or they may cause prejudice to the person charged, or such irregularities are likely to vitiate the proceedings, it will consider whether the whole inquiry should be set aside and a fresh inquiry started de novo, or whether the inquiry be set aside from the stage of occurrence of the.
That's all right, but there are decisions of the Supreme Court on
Yes,
this.
yes, my lord.
Yes, what is that? What is the principle for de novo inquiry?
I have a decision.
You tell me what is the decision. What
Yes,
is the
ma'am.
law, you ratio of the decision? you
Yes,
tell me.
yes, my lord. My lord, decision, my lord, in 2015 3 GLR 152, my lord. Para number 13, my lord. Rule 9 lays down the procedure for imposing penalties.
Oh, Mr. Your name, please, your Mr.
That's my lord.
P. Das.
Yes, my lord.
I'm asking you, what is the law, what is the principle regarding de novo inquiry? Tell me that you are reading from the judgment. You tell me, do you know what is the principle?
My lord, the principle regarding the de novo inquiry is that, my lord, that's the second inquiry, my lord. In terms of the second inquiry,
Do you know what is the principle? You know or you don't know?
my lord, I have been relying upon the decision at this.
I am asking you a very straight question.
Yes.
Do you know what is the principle of law governing de novo inquiry? Yes or no?
No, my lord, but
You don't know.
my lord, I am relying upon some decisions herein right now regarding de novo inquiry, my lord, because my.
What, I'm not reading any judgment. I'm asking you, are you aware what is the principle applicable in case of de novo inquiry? Nobody is rejecting your case. But I'm asking you, do you know?
My lord, at this moment, my lord.
You don't know.
I don't know.
I'll take up your matter at 11:30, find out
Yes.
and come back.
Okay.
Yes. Or at 12, 1 hour you have, go to the
12,
library,
12.
check up the law and come back.
Yes.
Item
Don't get printouts. I want you to tell me what is the law, what is the principle. Yes.
My please, your lordship. Lordship, petitioner's father was serving as Lord Mondal, my lord, expired on 1/1/12. Thereafter, he approached the before honorable court, this court, page 33. By this order, my lord, honorable court provided that the case of the petitioner may be considered and examined in terms of the Otsu Torundan Das and Procedural Nessa case. Page 35, thereafter, my lord, the page 35, the circle officer estimate number 4 after honorable court's order also forwarded the application to the deputy commissioner. But till date had not been placed before the DLC. Madam.
So this died in harness in 2012.
Well,
You want a mandamus today to give him compassionate appointment.
at least, my lord, might
Can it be given?
my lord, not considered, my lord. DLC.
No, if it is considered today, can it be given today?
My lord, maybe, my lord.
Maybe.
At least, my lord, maybe considered because
You will also have no answer, obviously, except for saying that time to obtain instruction. That is how these matters are gathering dust in the court. Why don't you come a little prepared? Why don't you come a little prepared and tell the court what is the issue from the government side? Huh? Government advocate's role is not only to say, give me time to obtain instruction. Then it is all expertise. You are just working as a postal department extension. You got the copy of the petition. You are unable to say anything. Well, we have seen it, it's happening in almost all cases except 1 or 2 where somebody is interested. Every case, there is no response from the government. You should read the brief and ask whoever is to be asked, what is the point here? Can a compassionate appointment application be considered after a lapse of 11 years? Can it be or can it not be? Yes or no? You don't know.
No,
And that's
Lordship.
bad. That is very bad. Every day there are half a dozen cases of compassionate appointment coming up in this court. The only response I hear from the government advocate is 4 weeks time to obtain instruction. And when you ask for that, we are unable to even pass an order. There are a number of judgments, number of circulars. The policy has changed, the criteria have changed. You are not aware of anything. But Mr. M.R. Khandakar, learned counsel for the petitioner. The petitioner is aggrieved by non-consideration of his claim for appointment on compassionate ground. It appears that the father of the petitioner, who was serving as a lot mandal under the circle officer of Ojai Revenue Circle, had died in harness on 1/1/2012. Hajo Revenue Circle had died in harness on 1/1/2012. Full stop. It is doubtful as to whether such an application can be considered after the lapse of more than 11 years. However, since the learned government advocate Assam seeks time to obtain instruction, this matter will have to be examined after notice. Full stop. Issue notice of motion returnable in 6 weeks. Since Ms. S. Burwal and government advocate Assam has appeared and accepted notice on behalf of all the respondents.
No, 2, 3 and 4.
2, 3 and 4. So Mr. S. Datta, Standing Counsel, Revenue Department, Assam for respond number 1 and so and so for respond numbers 2, 3 and 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned Departmental Counsel so as to enable them to obtain instruction.
Lord, may I pray to pendency, my lord?
Item 9.
May I please, your Lordship? Lordship, this matter pertains to a departmental proceedings, my lord, initiated during the early months of 2019. Now, my lord, thereafter an inquiry committee was instituted. The committee submitted its report and charges were framed and personal hearings also took place. But my lord, since it has been 4 years, my lord, this whole departmental proceeding has not been concluded, my lord. On this aspect, my lord, I would like to rely upon
Just a minute, just a minute, just a minute. So you are aggrieved by delay in conclusion of the departmental proceeding.
Yes.
When was it initiated?
my lord, on 13/2/2019, my lord.
So
He
the
was,
delay is about 4 years.
4 years, my lord. And I would like to rely on a court judgment, my lord. Thanks. Paragraph 13 is the relevant. My lord. 33, sorry. my lord.
Paragraph 13.
33, 30.
Yes,
If I may, my lord.
yes, please.
Keeping these factors in mind, we are of the considered opinion that every employer, whether state or private, must make sincere endeavor to conclude the departmental inquiry proceedings once initiated against the delinquent employee within a reasonable time by giving priority to such proceeding, and as far as possible, it should be concluded within 6 months as an outer limit. Where it is not possible for the employer to conclude due to certain unavoidable causes arising in the proceedings within the time frame, then efforts should be made to conclude within reasonable extended period, depending upon the cause and the nature of inquiry, but not more than a year.
Yes. What do you have to say, madam?
Notice me, your lordship, why it become delay.
No, it's been 4 years, my lord. So,
All right,
yes.
but we have to give them some time. You are Mr.
Peace in harmony.
Heard Mr. P. Sinha, learned counsel appearing for the writ petitioner. The petitioner, who is an employee in the establishment of Deputy Commissioner Kamrup Bracket Metro and working as a research assistant, is facing a departmental inquiry which was initiated in the month of February 2019. Full stop. The departmental inquiry has not been concluded till today. Full stop. Aggrieved by the unreasonable delay in conclusion of the departmental inquiry, the petitioner has approached this court by filing the instant writ petition, seeking a writ of mandamus to actually, you want them to conclude it, not to set it aside. Huh? You have missed out on that, Mr. Sinha. Seeking a writ of mandamus. So they will conclude it. The law is that if it is unusual delays there, the proceedings can be set aside. That's how you file a writ petition, not. Anyway, that's why I keep saying you must read the law before coming to the court. That is what is creating a lot of problem. I see later Ms. S. Borwal, I'm a government advocate Assam, appearing for the respondents. Pray for some time to obtain instruction. Prayer allowed, issue notice of motion returnable on 20th of March 2023. Since Ms. Borwa has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel so as to enable her to obtain instruction and appraise this court as to the stage of the departmental proceeding and the reason for delay in conclusion of the same. Written instructions be obtained from the concerned authorities. Full stop. It is also made clear that pendency of this writ petition shall not be a bar for the authorities to proceed with and conclude the departmental proceedings in accordance with law, if so advised.
God bless you.
Item 10.
Yes,
May I please also, my lord, it's not before lordship, my lord, they are graduate, my lord, and they belong to civil service committee of Karbi Angan, my lord. They are eligible for, my lord, Assam Civil Service Junior Grade and Allied Services, my lord. My lord, the PSC, my lord, issued an advertisement, my lord, for preliminary examination for screening the main examination. My lord, on 22nd December 2002. Lordship, my annex 3, page 22, my lord.
page 23.
22, my lord. Lordship, my cell number 1, Assam Civil Service Junior Grade, my lord. Here, my lord, in case of reserves for STH, my lord, so nil, my lord, 0, my lord. So here, cadastre is, my lord, 86, my lord. So as for the reservation policy, my lord, at least it should be four posts for the schedule tribe hills, my lord, at least, my lord. So if they are utilized, my lord, suppose they have said that it is utilized, but in a place recruitment person cannot be utilized, my lord. And last year it should be more recruitment than the numbers, my lord. So that's why, my lord, we approach the honorable court, my lord, to, my lord, if, my lord, the respondent authority, my lord, how they have utilized.
Mr. Mohanto,
That is not our domain, matter. That will be answered by the government, matter. Because APSC matter publish the as part of the advertisement given by the government regarding vacancy for issue.
No, I have taken the telephonic instruction, the vacancies are notified as per the roster point. The roster point reserved for the STH is already persons are there. That is why the STH it has not been advertised.
no, already persons are there, means then you have to tell us what is the total strength.
I'll take that. The telephonic instruction I today in the morning I have taken. Out of the total cadre strength, 5% has to be for the STH. If that figure is already there, persons are already there, so the STHs may not be advertising.
That's correct.
I'll take, that is what they have said.
Okay.
And the petitioners have come after the last date. Last date has long back gone.
No, they have not applied.
I don't know.
No, my lord.
Petitioners have applied.
Applied, my lord. One applied, my lord, one did not apply.
One applied and one didn't apply.
My lord.
I'll dismiss the writ petition.
My lord.
The person who has not applied, how can he come here?
My lord, when there is a no estimate better, he was my lord.
No,
chief
Mr.
of the-
Sarania, we have,
One applied, my
those
lord.
days are gone.
The petitioner number two. applied.
Anything and everything will not work in the High Court.
No, my lord, petitioner number two applied, my lord.
Then we can't
petitioner
pass
number,
on it.
number one, my lord.
Other writ petitioner doesn't have any right. Why have you clubbed them together?
My lord, he thought, my lord, he did
He
not apply
thought we
because of.
don't agree with his
My
thought.
lord, I delete my name, my lord. Right?
Huh?
Delete my name, my lord. but
You
my-
delete your name, let him get an instruction in the
My
meantime.
lord.
In fact, para one of the petitioner, they have sought for that only, that the record.
No, Mr. Sarania, perhaps it will be better you withdraw this and file afresh, because your pleadings will be all haywire. And you see, we are going to look into these matters like a court should look,
My lord,
because this is not a charitable institution.
my lord.
Okay, we can understand sometimes poor people who do not have adequate means, asking for minimal amenities of survival, we can be liberal. But these are matters, appointment matters, ST quota, these, that, you need correct pleadings. The right person should be there, otherwise why should we trouble them?
My lord.
We will not trouble the government with all these things.
Before that also by the representative, we approached the authority, my lord.
Representation has been given to APSC.
Anyway, my lord, I
not
make-
to personal department.
Liberty to file a fresh, my lord.
Of course,
My
file afresh. You file afresh, and now you know, there, according to them,
My lord.
there is no backlog vacancy.
My lord cannot be, my lord, because you said they have wrongly calculated possibly, because my lord, suppose last year maybe more recruitment than required, my lord, if there is no vacancy. How it can be, my
No,
lord?
there also he has a point. How can you fill in advance the vacancies of
The
coming year? If
vacancy,
you have done it, then the whole process will be set.
Why they have done more?
that will be a case for fresh recruitment. The persons are getting their.
No,
superannuation.
Mr. Nath,
Logic.
please understand the point.
Logic.
Let us apply our minds
Yes,
and
yes.
go to the issue in a rational manner.
True.
You have to keep 5% reserve. That option is not there not to do it. Correct?
5%
Now-
of the cadre strength.
Cadre strength, right?
strength,
Now,
not
assuming that
vacancy.
there are 100 posts,
Logic.
you cannot fill up 10. You can't say that 5 posts for this year, and for the next year, another 5 we are also filling up today.
No,
You can't do that.
On superannuation, vacancy arose. Because of superannuation of the persons who are in service,
Hmm.
vacancy arose at the end of the year.
But were they promoted as ST Hills category or as general people who
I'll-
belong to ST Hills?
I'll take that instruction. My instruction says that out of the cadre in the SES junior grade,
Hmm.
out of the total cadre, persons are available in the their.
All right, then you get that instruction, then we'll close
Let
it.
them come, let them come with the new petition. I'll take, because as on today, my telephonic instruction is that is what I am
All
playing.
right,
Let
on the
them come.
request of Mr. M. Saranya, Learned Counsel for the petitioner. This writ petition is permitted to be withdrawn with liberty to file afresh after rectifying the defects in constitution of the same. Mr. Dinath, Learned Senior Government Advocate Assam, and Mr. T.J. Mahanto, Learned Senior Counsel assisted by Ms. P. Sharma for the APSC authorities are present and do not have any objection if the prayer is allowed. You file it on Monday, make a
My lord,
mention.
my
we'll
lord.
allow it.
My lord,
But the pleadings has to be correct.
my lord,
Yes.
I love this.
Lordship, we have to challenge the order of imposing penalty. Order of imposing penalty, Lordship. In this particular case, allegation was a forgery that has not been established and that has not been proved by the inquiry research report. Thereafter, Lordship, a penalty has been imposed for 2 increments was down, Lordship, and that imposed, I have filed appeal also dismissed. After that, I have come before the Honorable Court.
Hmm. So what is the relief you are seeking?
Lordship, kindly see page 64, the finding of the inquiry officer.
Just 1 minute. So this we have to issue notice.
Yes, Lordship.
All right.
No intervention.
Heard Mr. S.K. Goswami, Learned Counsel appearing for the writ petitioner, assailing the inquiry report dated 15/12/2020. And as well as the order dated 9/12/2020 passed by the appellate authority, rejecting the appeal filed by the petitioner against an order of penalty. The instant writ petition has been filed. First up, Mr. Goswami submits that the impugned orders are vitiated by non-application of mine. Mr. R.M. Das, Lani Standing Council, WR Department, Assam, praised for some time to seek instruction in the matter. Issue notice of motion returnable in 6 weeks since Mr. Das has appeared and accepted notice on behalf of all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to Mr.
2 days.
Das
2 days.
during the course of the day so as to enable him to obtain instruction and file affidavit. List this case again on 29th of March 2023 as a fixed item.
Obliged. Deeply obliged.
Supplementary list item 49.
And the two categories of MDs, one is headquarter and district level. Earlier, the proportionate was 30% to 30% and 70%. Now all are in the same category. Now if your lordship can you see page 32. 32 is the minutes, my lord. And relevant is the page 33. I'll read that last paragraph. After the gradation list, the objection raised by Srimati so and others for placing their names in the gradation list of LDA as per initial date of joining in the post of so was discussed. It has been observed that in the earlier practices, the incumbents who were initially appointed as LDA, Clipper so district were promoted to the post of LDA and eventually retired as register. The formula of 70% 30% promotion of direct recruitee and promotee respectively was adopted during the year 2016, where Sri so was promoted from LDA to LDA district level to LDA HOD. Considering the case of Chaudhary, who will be retiring on January 2022 without getting any promotional benefits till date, the committee has suggested a possibility of making 25% promotion from the promotee and 75% promotion from the direct recruitee, and entrusted both the parties to amicably arrive at a solution by themselves in consultations with all Assam Employees Association and submit their decision. Now this decision has not been finalized. Now they are holding a promotional meeting today. So if this is done without taking into any consideration this aspect of the matter, 25% reservation to the promotee, then it will, these persons will never get promotion in life.
You are the promotees.
We are the promotee.
And as per the, which is the resolution just you mentioned, page
Resolution
number?
page 32, my lord. 32, 33, last paragraph.
Page 32, yes.
33 is the last. The committee has suggested that the whole committee was there. They said 25% for promotion, but the association has to sort out the matter. Now the association has not sorted out the matter. Things are the final decision has to be taken by the authority as on date. But even then, my lord, their representing, my lord, committee has fixed today at 4 PM for promotional revenues. What I pray, my lord, let them take instructions on the matter not to finalize promotions with respect of UDA.
No, they'll finalize, but in accordance with the decision.
Yes.
Adopted on.
No, but in a gradation list, lots of can see page 28.
This resolution is for after the.
This resolution is.
No, Mr. Chutia, this is a, you see this resolution at page 32.
11/10/2021.
Correct. Are you disowning this resolution?
Well, I don't know at this stage whether dissolved or not. There's 21, more than 1 year.
Then we have to stop further promotion.
No, promotion, my lord, let them initiate the promotional revenue, my lord. So for Gedesol,
All right, heard, Mr. You would not say something which makes a sense in this case, Mr. Chutia.
No.
Either you tell us that this notification is no longer valid, or we have to say that you proceed as per the resolution. What is the third option available to the court?
Now, if it is not, my lord, dissolved, then they will go for the promotion by the resolution, my lord. That is, I have no objection, but whether that has been existed or not, I don't know.
All right, that will mention that if the same has not been annulled in the meantime.
Otherwise, in a Gedesol list, without they have claimed, they did not claim anything in provisional Gedesol list.
and their position as per the
This is
Gazettal
promotion to the post of
UDA.
post of. Take that hard, Mr. BD. Thus, learned senior counsel. Estate Bank. HR thus, learned counsel appearing for the petitioners. Full stop. The petitioners hearing are serving as LDA in the institute, in the establishment of
Director of Information and Public Relations Department.
Directorate of Information and Public Relations. Full stop. According to the petitioners, 30% of the posts in the rank of upper divisional assistant have been reserved for the promotee LDS, whereas remaining 70% is to be filled up by way of direct recruitment. Full stop. The aforesaid criteria has crystallized in terms of the minutes of the meeting of the. What committee is this?
October, 11 October, I think.
Crystallized as per the
11 October.
minutes of the
2021.
meeting dated 11/10/2021. Presided over by the Director of Information and Public Relations, Assam, as the chairperson. First of, notwithstanding the same, Mr. Das submits that the respondents are seeking to fill up all the 6 vacant posts of UDA by means of direct recruitment, by depriving the promotee candidates. Full stop. Hence this writ petition. Full stop. It is also the submission of Mr. Das that the process of promotion is being held today, and unless an interim order is passed, the interest of the petitioners would suffer serious prejudice. Full stop. From a perusal of the materials available on record, I find that there is a decision reflected in the minutes of meeting dated 11/10/2021 to the effect that 30% of the posts of UDA shall be filled up by promotees and the remaining 70% by promoting the direct recruits. Full stop. If that be so, the plea raised by the petitioners prima facie appears to be genuine. Full stop. Mr. Chutia submits that the only question, Mr. T.C. Chutia, learned government advocate, Assam, submits that the only question that would arise is as to whether the MOM dated 11/10/2021 has been modified in the has been modified at any subsequent stage. Full stop. Be that as it may, in view of the issues raised in this writ petition, I am of the view that the matter would call for further consideration. Full stop. Issue notice of motion returnable in 4 weeks. Since Mr. Chutia has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned government advocate Assam within 3 days from today. Hard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that the respondents may go ahead with the process of promoting candidates to the posts of UDA.
6 posts of UDA.
6 posts of UDA bracket HOD, if so advised, but the process would be carried out in accordance with the decision reflected in the MOM dated 11/10/2021 bracket annexure 11 bracket close, if the same is still in force.
And actually, instead of 30%, it should be 25%.
But the
It is 25%.
75 and 25.
75 and 25. Okay, then make it 75 and 25.
I can 50.
Instead of 30, make it 25 and 17 is 70.
Lordship, the petitioners, my lord, the other, my lord, my lord.
These are policy matters. These are policy matters. What can we do? You got it because of the policy. You lose it because of the policy. What can the court do about it?
My lord,
You see, others are not getting it. Only those, and is Northeast such a bad place now? Things have changed.
My lord, that is the on the my lord, one hand, my lord, the exponents, my lord, not my lord, withdrawn the my lord, non-family station in the north region. But
They
other
will
than-
withdraw the non-family station
then
status.
my lord,
That's
it is my lord, if my lord, family station, then no problem, my lord. But
What do you
still,
have
my
to
lord,
say?
this is not family station.
Without instruction, I cannot say.
My lord, even my lord, my kindly see my lord, the page 102, earlier
All right,
notification.
we'll issue notice on main as well as interim prayer. Huh? You have time till 31st March.
Yes, sir.
Yes, we'll do it on 17th of March. Heard Mr. Alan Dehinga, learned counsel for the petitioner. Peruse the amendments made in the writ petition. The petitioners are aggrieved by the memorandum dated
6 October 2020.
6/10/2022,
Page 102.
withdrawing the incentive of retention of general pool government accommodation of Group A officers who are posted in northeastern region, including Sikkim. Full stop. According to Mr. Dehinga, since the non-family station, non-family within quotes, station status is still in force for the employees in Northeast, the notification dated 6/10/2022 is not sustainable in law. Mr. K.K. Parasar, learned CGC, prays for time till. All right, we'll make it 13th of March. 13th of time, pays for 3 weeks time to obtain instruction in the matter. Prayer allowed, issue notice of motion returnable on 15th of March 2023. Since Mr. Parasar has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned CGC, requisite in numbers within 2 days from today, so as to enable him to obtain instruction. Heard on the prayer of interim relief. The last date for vacating the quarters is 31/3/2023. As such, the prayer for interim relief will be considered on the returnable date.
Obliged. Yes, sir.
Yes.
For admission, I think 12.
Please, Your Lordship. This matter, Your Lordship, I am challenging the enhanced punishment in the petitioner. The departmental inquiry. The punishment was enhanced without following the rules, first, and secondly, Your Lordship. The punishment that was initially given was on the consideration that the inquiry officer did not finally prove the proceedings against the petitioner. So that is basically the case, Your Lordship. And
So this
third,
will take some time.
this is the issue, Your Lordship.
No, if you are, you want to argue, I'll take it up, but then these matters will be taken up last. We can't spend 45 minutes in a matter in the middle of the day. That upsets
It is
the
up
whole-
to Your Lordship.
Yes. If you can wait, then we can take it up later in the day. Or else go for a non-miscellaneous day.
I leave it to Your Lordship. I have
No, no, don't leave.
Because otherwise also.
We have to go by the record also. The record is also available.
Record is not there.
Available. Records are available.
Then you wait, we take a chance after the other matters are over. Let us finish up the orders and all these things, then we'll
Yes.
come back.
It will also not so long, but some time will be required because the Lordship will have to go through the department.
Correct,
May it please your lordship.
Yes.
No, this is a matter wherein the petitioner is praying for promotion from grade 3, grade 4 to grade 3 middle. That is from the post of peon to junior administrative assistant. No, similar issue has already been
You are
decided.
asking for disposal.
If possible.
No, we will do it, but then you have to wait. Let us go through other matters and then do it. This will take a little time.
A little bit of time.
You see,
Otherwise, my
nowadays
case
what
is-
happens is these matters were never decided in admission. But nowadays the bar wants no hearing.
Otherwise, my lord, it's a covered matter. Already there is a decision by this honorable court.
Which is the decision?
Yes, my lord. I'll just take.
Who is for the respondent?
Mr. Nayak appeared for. The decision lordship will find page 63.
No, but you don't have your other side counsel. What is it? This is Government of Assam Water Resources Department.
Yes. You know, the issue is that
Hmm.
they rejected my case saying that I am not an employee of GAD department. I was an employee of the Water Resource Department. Here also, same issue was raised. Objection was raised that he was an employee of the PW department, not the GAD department. On that count, promotion was denied. This honorable court may not held that nothing doing. He is an employee of GAD department, so we have to consider his case for promotion.
Where is that order?
Page 63. In fact, this person was junior to me.
Right, let Mr. Nair come. We'll take it up after that.
What's I'm here, Lord?
No, This is a covered case.
No, Lordship.
Then we'll take it up after some time.
Much of this.
Item 15.
So in this case, my lord, the respondent has not filed affidavit, my lord. So its affidavit is required in this case.
Respondent is not even present. Forget filing affidavit. Who is the respondent?
PWD, my lord. 15.
What is the matter about?
My lord, this is the regarding the regulations of the.
Lordship, I kindly see the last order, Lordship. I am appearing for BTC and your Lordship directed to serve copy of BTC, Lordship.
We have-
That was not done.
We have served the copy in the day, my lordship, before this.
And today morning, so I talked to the officer. I'm sorry. While,
That day only we have given the copy, my lordship.
So let us hear today on service of copy.
No, this is not my signature. I'm sorry, Lordship. This is
Then
not my
the-
signature.
Office only.
Lodge and FIR.
Sorry, Lordship, this is
No,
not
what
my
to do? I mean, the High
Lordship,
Court
today I
cannot
talked
get.
to the officer, Lordship,
Hmm.
and he said in the meantime, they have already retired. That was their instruction today morning itself.
So, what is the relief they want?
They want regulation of their service, or they were working against some temporary post as junior engineer, Lordship.
Hmm.
Subsequently, in the year 1990, their services were terminated. But he went to the court, Lordship, and in terms of court's order, he continued. And recently he retired, they told me, Lordship.
In
Detailed instruction I do not have.
2022, my lordship, in the month of October, he is in superannuation, my lordship, from a long time. He is getting all the privileges, my lordship.
Can you give him copies afresh?
Yes,
At least two copies.
today only I will
Today.
give. Okay, okay.
Heard Miss so your Miss.
These are-
Counsel for the head petitioner. Also heard Mr. P. Nayak, learned standing counsel PWD Assam submits that due to want of extra copies of the petition, he could not obtain instruction in the matter. First up, the petitioner's counsel has undertaken to furnish him copies of the petition during the course of the day. As such, on the request of Mr. Nayak, let this matter be listed again after 3 weeks as a fixed item, so as to enable him to obtain instruction.
Lordship.
Can it be before 3 weeks? Can it be on 2 weeks, my lordship?
No, it cannot be. What will happen?
My lordship, petitioner not getting the GPA for all the.
No, but
benefit, my lordship.
3
That is
weeks
it.
and 2 weeks, what will happen?
Okay, sir.
All right.
Oblige, your lordship.
Item 16.
So in this case, we I would pay some time. In fact, the affidavit reply was misplaced.
Time for, on what grounds?
No, in fact, let the matter be taken up next week. I will.
No, you are asking as if we have no other business
no,
for the next week. You ask for a date after, on the 5th week. We can consider. Matters are lined up.
Understand.
This request that today I don't want to do it, I want to do it on such and such. That's not going to work
At
out.
the convenience of the court of.
Minimum 2 weeks all adjourned.
Lordship.
We cannot upset our own
No,
roster.
that is my lord, I just I pointed out, my lordship, at your convenience, my
You
lord.
want to file any rejoinder?
No, in fact, they have filed, my lord, that, my lord, if the copy was not with me, my lord. Today I received a copy, my lord. So,
Achha, what is the matter about?
my lord, here, my lord, the maintenance under section 92 of the Indian Air Force Act, my lord. My lord, I'm for the husband, my lord. The wife, my lord, she filed an application under for grant of maintenance under section 92 of the Air Force Act. And an amount was released, 13,800 per month. In fact, my lord, that they have a my lord, Air Force order, my lord, which requires compliance. Here, what has happened, my lord? In violation of the Air Force order, my lord, an amount was imposed upon us. In fact, my lord, the respondent, my lord, respondent number 4, she has filed a maintenance case. Divorce case is pending before the competent courts, my lord. And my lord, the quantum of maintenance is under challenge before this court.
What was the amount?
13,800. Because it can as per the Air Force Act, Air Force order, it has to be 1/4. So, it could not have been, even as on date, 13,800 is being deducted regularly.
All right. We'll give you on 20th of or 22nd of March. 22nd of March.
After 22nd.
Huh?
After 22nd, madam.
After 22nd. Then 23rd?
24th,
23rd is after 22nd.
25th.
25th.
Earlier they had taken much time, my lord.
There is no such thing, madam.
Mr. R.D. Learned
Not
Counsel,
from my side.
we should submit that some papers were missing in his record and therefore the admission hearing of this matter be adjourned. Mr. S.K. Maybe Learned CGC and Mr. K. Sharma Learned Counsel appearing for the respond number.
1 to 3 million
I
SPD,
for
four,
number 4, my lord.
respondent number 4 is
CGC for 1, 2 and 3 and Mr. K. Sharma for respond number 4 are present and do not have any objection if the prayer is allowed. On the request of Learned Counsel for all the parties, this matter is adjourned and is directed to be listed again on 25th of March.
25th, my lord, is 27, 26.
24th of March. 24th.
27, my lord.
25th is a Sunday, Saturday.
27.
27.
27.
I think 17.
This matter relates to payment of pension, my lord. The petitioner, before lordship, my lord, was appointed as skilled labor under the respondent authorities, my lord, on date of her husband. Under the compassionate ground, my lord, she should have been appointed against a regular post, but she was appointed as skilled labor. And my lord, she was appointed on my lord 2/8/1996. And in the meantime, my lord, she retired from her contextual and employment, my lord, on 31/10/2019.
Where is the order of appointment of the petitioner?
There is no appointment. No order on verbal, my lord, on the basis of verbal appointment, my lord, she was engaged. It is admitted case that she was engaged and she was engaged on date.
When was she appointed?
My lord, she was appointed on 2/8/1996.
Where is the statement in the writ petition?
Yes, my lord. Paragraph 3, my lord, page 6.
So petitioner was getting pension, family pension on account of her? Huh?
Yes, that is, she got family pension.
You have to do a lot of labor. Otherwise, it will take me 5 minutes to dismiss your case.
My lord, I have twofold argument, my lord, in this case. My lord, first line of argument is that my lord, her appointment should have been made against a regular post instead of my lord, contextual basis. Because under the scheme of compassionate appointment, my lord, appointment should be made against a regular post.
But it was not made against a
It
regular.
was not made.
Then what can be done now? How can there be pension against a post which she never occupied? See, there are financial norms in every state. A particular post, which is a sanctioned post, carries a pay scale, other service benefits, pension, etc. So person holding that post will not only get the pay scale, but on retirement will get the pension.
My lord, the rule 31 does not contemplate that, my lord. Under
So
rule
you
31,
identify the post again which the pension can be given, and I'll pass the order.
my lord, for payment of pension, my lord, a post is not required.
Hmm.
Under the scheme of the government as well as the pension rules also, my lord.
Post is,
Post is not required, my lord.
where is the judge law? Let's see.
My lord, rule 31, if you lordship peruse the rule 31 of 1969 rules, my lord.
Mr. Chutia, what would you say?
I am saying, my lord, the petitioner is projecting the case that he is appointed as a master worker. He is working as a master worker. I am saying that he is a daily wages labor, and she was paid a scale as per the table 45 of this our honorable court. And she was not engaged in any sanctioned vacant post. She was daily wages earner. The daily basis, on a daily basis, she was engaged. There is no appointment letter. In earlier occasion also, this question was put to the petitioner. Where is your appointment letter? There is no appointment letter. Daily wages, there is no any appointment letter. We are not appointing anything. We are allowing it. The question of compassionate appointment does not arise. Her engagement is not on compassionate appointment. She was getting the family pension, and she was only engaged in the daily casual labor amount. She is getting like that as per table 45 says, paragraph 23, that minimum scale should be given to those persons and no pension at all. That is the case. So petitioner, there is no appointment letter at all. What post is holding and what is he confirmed or not, government employee or not, it is not. Casual. That's why not allowed. I'll have to address that issue. So losses tables the rule 31 of the Assam Services Pension Rules, my lord. Condition of qualifying service.
Who is appearing with the finance department here?
I have also filed an
What is your stand in this matter?
Lordship, it appears, Lordship, she was never appointed against any compassionate appointment, Lordship. At least one approval of the authority would have been there, one appointment letter would have been there.
See, Mr. Saikia, if you want to get rid of it today, you are welcome to argue. I'll dismiss it. Because you have no case. If there is any fiction, any theory you can come up with, it is your call. Or if you want to argue today, you are welcome.
My lord, well, there is a policy of the government that even if a person is a service of a person is not confirmed against any post, my lord, she is at the
No,
pension.
but the appointment, what is the appointment? We have to see that.
And in
Question of pension does not arise without
recently, my lord, the honorable apex court also,
Hmm.
in the case of ad hoc employees, my lord, honorable apex court held that, my lord, after rendering service for 20 years on ad hoc basis, respondents cannot question the ask for regularization for payment of pension. That judgment is also there, my lord. I also rely on that.
You rely on those judgments, but I'll dismiss your petition because there is no indication as to how she was appointed, what process, which post, nothing.
No, my lord, but in the affidavit, they have stated that, my lord, I was appointed on death of my husband.
That's right. Death of husband is not the mode of appointment. That could be the
Yes,
consideration.
but my lord, that if I am appointed after the death of my husband, that is necessarily the compassionate appointment, my
No,
lord.
that is naturally for you. For the court, we have to pass orders which are laying down precedents. We cannot go on passing orders in air and then somebody will say similar order, give me similar order. Those things this court will not create. You come up with a crystal clear case. What was your, against which post you are appointed, on what basis, what then we'll apply the law. Facts have to be clear. You are only saying that after death of my husband, petitioner was appointed.
Yes.
No
appointment is
order,
engaged.
nothing where if his argument is correct, then you can't get it.
I'm not disputing that, my lord, my initial engagement was,
So is your client getting the family pension on account of her husband?
yes, madam. Is getting.
I think she will have to-
Every member, my lord, they get family pension, even if they get the family pension, my lord, they are entitled to compulsory appointment also, my lord, under the
So
scheme,
that's all right.
my lord.
But the point is, this kind of completely unknown is the process of appointment. We can't issue a mandamus that pay her pension.
That's not the appointment.
That apart, my
engagement.
lord,
That cannot be done.
apart from the pension also, she is entitled to the gratuity, my lord. Gratuity is also not paid till today.
So it's not
So which
appointed,
is, huh?
engaged only, not appointed, engaged at daily wages. So your question of paying.
Heard Mr. Ayed Sekar, Learned Counsel for the petitioner, also heard Mr. T. Chutia, Learned Additional Senior Government Advocate Assam appearing to the state, as well as Mr. P. Nayak, Learned Standing Counsel Finance Department.
If the lawsuit is disposing of the matter, my lord, I'll have to place the decisions, my lord, I'm relying on my,
You do it on some other day.
my lord.
I don't want to dismiss today. Tell me a date favorable for you for dismissal.
In the next week, if possible, my lord.
Mr. Saika, come up with something more. This is not going to work out.
I will satisfy,
Yes.
I will try to satisfy your lordship.
All decisions are rendered on facts which are established.
Yes, my lord.
The problem with your client is that nobody knows how she was appointed, against which post. If it is a completely illegal appointment, or if it is a master role, you cannot claim that relief you are asking for. We cannot fire a shot in darkness.
My lord,
That is not the purpose of a writ court.
in terms of the judgment of the apex court, my lord,
Hmm.
wherein it was held that, my lord, ad hoc employees are, my lord, even if they are not.
But she is not an ad hoc employee.
Same, my
Show
lord,
me where she is an ad hoc employee.
my lord, like, see the skill labor, my lord.
Huh?
Skill labor. They are
Show me the
admitted
proof.
case-
Show me the proof.
It is, they are admitted case that I am a skilled labor, my lord. I work as skilled labor since 1995, my lord, till my retirement, my lord.
No, but it is a master role.
Not master road.
Daily using is a casual.
Yes,
So is
They-
there any
they-
judgment which says casual laborers will be entitled to
my lord.
pension? If that judgment is there, you show
In the
me.
case of Jagdish Singh, my lord,
Hmm.
it was the master workers, casual workers, my lord, ad hoc employees, they were, my lord, put at par, my lord,
For what purpose?
for the purpose of getting the minimum scale of pay.
The
That was it.
minimum scale of pay, she has got it.
Yeah,
That is
got
as
it.
per the rate appeal order. That's what he's saying.
That is,
Is Jagdish
But that
Singh-
rate appeal order also says they will not be entitled to any further benefit after
Yeah.
retirement. Is it not?
We are
Yes,
giving
yes,
more.
So
my lord.
if you
We are-
rely on rate appeal order, then you are making my job easier to dismiss it.
not relying on that, my lord.
Therefore, I am saying be very clear what you want to project. Maybe you can still make out a case,
I will try, my lord.
but then
We are giving more than the Jagdish Singh. Jagdish Singh even does not allow the medical allowances like that. We are giving them. Even though they are saying, my lord, there's a question of appointment, my lord.
I have read the judgment in rate appeal.
Yes. Para
The idea
55.
was very different. Yes, if they would have stopped your salary, etc., then it would have been a different matter. You are asking for pension. Pension must be provided in the rules. Pension is a creature of a rule.
Yes, my lord.
So you cannot just hypothetically expect the court to pass orders of pension. You have to show us how you fit into particular
Yes.
limb of the rule.
Under rule.
That is what you have to
Rule
show.
31, perhaps, my lord, I am.
What is Rule
Okay.
31? Rule 31 of which rules?
My lord, Assam Services Pension Rule 769. Page 23 of that book, my lord.
Page 23 of this
Well,
book.
no, my lord, the other book. Page 23. Another proviso, my lord.
Hmm. So how does 31 help you?
My lord, my lord, firstly, my lord, the service must be under the government. That is clause 1, my lord. Secondly, the employment must be substantive and permanent.
Yes, that's what the question we are
Yes, my
asking
lord,
you.
that is why I will come to the proviso, my lord.
Ah,
The thirdly, the service must be paid by the government. I was paid by the government.
all right.
Yes, provided that the governor may, even though either or both of the condition 1 and 2, the above two conditions, my lord, above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension.
Right.
And in individual cases, subject to such condition as he may think fit to impose in its case, allow service rendered by any officer to count for pension. So, my lord,
The High Court cannot exercise the power of government. You are asking the High Court.
no,
to exercise
I could
the-
direct the governor to, the commissioner secretary to give a declaration, my lord. Because, my lord, in on case, my lord, in 2005, I think, my lord, Honorable Justice R. Gogoi, my lord, directed the.
Where is the order? Show me. Don't talk about court
I'll place
orders.
on next date, my lord. I'll place.
Don't talk about court orders without placing it. If
I'll
you want to rely on an order, show me that. If that is the law, I'll follow it.
place it.
Any decision which is applicable, I'll follow it. There's no difficulty.
We are engaged in daily wages in our home also, we will have to give a pension.
This will open a Pandora's box. If
There should be post.
we have to follow some norms.
But otherwise, they are entitled to the gratuity, madam.
Hmm?
They are entitled to the gratuity.
No, isn't that right?
Gratuity part, they are.
Yes. What does the government say on that? Mr. Nayak, what about the gratuity claim?
Nothing.
No,
He's saying,
it's neither a temporary lordship nor a permanent.
huh?
It's neither a temporary employee nor a permanent employee.
There are
circulars of government of Assam.
Hmm.
My lord, payment of pension is not associated with any regularization at all. If somebody has rendered service for 20 years, he is eligible for pension.
No, that's correct, but
Yes.
his problem is that they are saying it was a casual daily laborer and there is nothing to rebut that.
But
That
then
I'm
as far
aware.
as temporary employee is concerned, merely because somebody's service is not regularized.
That is okay, but that he doesn't fit into that.
So, my lord, I made a submission because so many matters are going on. So
Correct.
before lordship's taking a call on the issue,
No,
so
that's
lordship
right.
takes note of all the relevant laws, then it will be good.
That's what I told that he should
Those
come.
circulars, my lord, annex in the additional affidavit, my lord. That is in the pension book itself, lord. Circular, my in your colleague.
So you make up your mind, you want time or you want the order to be passed today?
I will make some more research.
All right. So, on the request of the petitioner, let this matter be listed again. We'll have it on a non-miscellaneous basis. 21st March 2023 as a fixed item. You come up, give the compilation, you say, the basic problem here is, was it a case of temporary appointment or not? What is the basis for us to record that that finding? You show us that. Rest of the things are all taken care of.
My lord, their affidavit says I was temporarily appointed as my lord, skilled labor.
Engaged, not appointed. There is no question.
That is the problem. That's
Yes.
why again and again you are coming back to the same thing. Engaged and appointments are two different things.
Different.
Your whole argument is based on appointment. But they are saying you are engaged and you have nothing to rebut that. You understand where the problem
Yes.
is. You have to work on that. If you can show us something, we'll accept it. But I cannot treat engagement as appointment. And that too without there being any material. Even a temporary appointment, yes, 20 years will be treated as regular. Regularization per se doesn't mean much here. Then if the rules say that 20 years you are entitled to pension, you will get it. But they are not admitting you were appointed on temporary basis. And you don't have
There is no
anything to say.
appointment as such in this case,
That's
my
the
lord.
problem.
There is no order of appointment.
That's the problem. So work a little on this and give us some assistance. If you can convince, I will, but on these facts, difficult to allow. unless you can develop your case. Yes.
May I please, your lordship?
Hmm.
Lordship, in this matter, I have received the instruction, my lord. I like to file my affidavit, my lord. In 3 weeks time may be granted, my lord.
You are appearing for whom?
But only thing that I just point out to him. If he has to make a specific reply on that, page 200 and
That will not talk. Let him make his reply. I heard Mr. B.P. Pora, counsel for the petitioner, also heard Mr. S. Datta, Lani Standing Counsel, PNRD Assam, appearing for the response numbers 1 to 6, 8 and 10 to 28.
1, 2, 3, 4, 5, 6, 8 and 10 to 28.
As well as Mr. P. Nayak, Standing Counsel, Finance Department, Assam, appearing for response numbers 7 and 9. The Respondents' Council have submitted that some more time is required to obtain instruction and file affidavit. In view of the above, admission hearing of these matters stands adjourned for 4 weeks.
Hello.
Item 19.
Hey, please, your lordship. My lord, we have received the instruction. We'll file affidavit, my lord.
You are for whom?
I'm for, on behalf of Standing Council, APDCL, my lord.
Standing Council?
APDCL.
How much time you want?
3 weeks may be given.
Mr. Nath?
Maybe allowed by the last.
Yes,
occasion
heard
also.
Mr. S. Nath, Land Counsel for the petitioner, also heard Land Standing Council, APDCL, or some who submits that instructions have been received. And therefore 3 weeks time be granted for filing affidavit. Since
Last
prayer-
as my lord, last occasion
prayer is
also.
not
deputy.
opposed, same stands allowed. Let this matter be listed again after 4 weeks. Affidavit on behalf of the respondents be positively brought on record within 3 weeks. from today.
Obliged, lordship.
Timing matter item 7.
May I please, your lordship?
Hmm.
My lord, the principle laid down by the apex court in regard of Denovo inquiry, my lord, is that holding a Denovo inquiry, a fresh inquiry, on the same set of charges, on the ground that the previous inquiry is not acceptable to the disciplinary authority is not permissible and is contrary to the law laid down by the apex court, my lord. Such action is forbidden as not being contemplated by me.
Heard Mr. P. Das, Learned Counsel, appearing for the petitioner, assailing the order dated. This is what, 23rd January. What is the date of the order?
My lord. My lord, it is at page annexure 10, page number 57, my lord. The date of the order, my lord, it's been wrongly recorded as 2022, my lord, but it is 2023. It's a recent order.
But is it in 22? How can we know?
It was on 23rd January 2022. Karan previous it was
23/1/2022. Ordering a de novo inquiry against the petitioner. The instant writ petition has been filed. Mr. Das submits that the improved order was actually issued on 23rd of January 2023, and the date has been wrongly recorded therein. Full stop. However, according to the learned counsel for the petitioner, a de novo inquiry on the same set of allegations was impermissible in the facts and circumstances of the case. The petitioner has therefore prayed for an order, paid for an interim order protecting her interest in the matter. Full stop. Ms. M.D. Bora, Learned Government Advocate Assam, appearing for the respondents.
1, 2, 3, 5, 6, 7, my lord. Of
1,
4
2,
and
3, 5, 6, 7. Who is for 4?
the State Police Accountability Commission notice.
Prays for some time to seek instruction in the matter. Prayer allowed, issue notice of motion returnable on 22nd of March 2023. Since the respondent number so and so is already represented, no formal notice is required to be sent to them. Extra copy of the writ petition, requisition numbers be furnished to the learned government advocate Assam so as to enable her to obtain instruction. Petitioner to take steps for service of notice against the service of notice upon the respondent number 4 by registered post with AD within 3 days from today. heard on the prayer of interim review, having regard to the facts and circumstances of the case, as an interim measure, it is hereby provided that further proceeding in connection with departmental proceeding bearing number 01/2023 against the petitioner shall remain suspended until further orders.
Obliged.
May I please, my lord?
Yes.
In this case, my lord, by order dated 8/2/23, this honorable court has sought instruction whether the ACR has been communicated to the petitioner. My lord, department has sought for just a week time, my lord. Any suitable date next week, my lord. Just any suitable date.
All right, heard Mrs. Bora learning counsel for the petitioner. Also heard Mr. B. Decker, learned CGC appearing for the respondent who submit that he be granted 1 week's further time to seek instruction as per the order dated 8/2/2023. In view of the prayer made by Mr. Decker, this matter is directed to be listed again
Next Friday.
on 27th of February 2023 as a fixed item.
Deeply obliged, my lord.
Item 21.
Mayfield Lordships.
Yes,
The Lordship may
just
record-
1 minute.
My lord?
Just 1 minute.
জয়েন কৰিছে জয়েনে দহটা কিলো ৰিলিজ কৰিছে তাৰমানে দহ মই জইনিং কৰি দিছো তাক জইন কৰি
Yes, has he joined?
Yes.
already yes, they released me.
I have the instruction. He has joined.
My lord, they kept me under suspension, my lord. And there is extensive order by this court. I will release only on appeal lordship's order on 10th of this month, and I join in 12th.
So he has been allowed to join where?
He has joined at district jail Karimganj.
Karimganj.
Now he will get his regular salary. Now he will get his
No,
regular salary.
No, I am entitled to regular salary from the date of my suspension because they released me only on this month after lordship's order. They hadn't released me so long. After he was released on 10th of this month, then he's reported on 12th.
So we'll ask them to pass appropriate orders. If you are aggrieved, then.
No,
you
my
can-
lord, I am now on the watching of the proceeding. The MP in order of punishment, 3 punishments were given. Transfer, the my lord, the reduction in increment, and my suspension.
No, suspension is not a punishment, my lord. But what I am having-
Suspension is over, you have joined back.
Yes, yes.
Anyway, now, your lordship can leave without following the procedure of rule 9. They say in their affidavit, rule 9 is to be followed.
No, Mr. Sharma, let's go one by one.
My lord,
Your,
with lordship's permission, I have a submission, my lord, if my friend allows, my lord, now in the affidavit and reply, he has annexed a departmental appeal copy. I have taken the instruction, they said that they have not received the appeal earlier, but in the reply, I have seen that he has filed a departmental appeal. Punishment is stoppage of 1 increment. Departmental appeal he has filed before the appellate authority. Let this appeal be considered at this stage, my lord. Only the punishment is that, and he has taken all the grounds I have seen. At least in the reply, the appeal is available. I will tell them that they will consider within a time. Otherwise, within 60 days period, appeal is to be filed. They have not filed. That lordship will consider.
let them consider your appeal. You have filed an appeal.
Yes.
My lord,
In the affidavit in reply, page 56.
I'll keep it pending.
No, 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 that can't happen.
Then a lordship will be here.
No,
Because
if they,
patently illegal. Why is patently illegal? Because your lordship can see.
Mr. Sharma,
Yes,
your immediate problem was they were not allowing you to join back.
yes,
Correct?
yes,
So that problem has been taken care of.
yes.
You have now joined.
Hmm.
He says you're going to get your regular salary. Correct? Your next problem is your period of regularization of service. During the
That is
period of,
there.
yeah,
Yes.
that we'll ask them to pass an order.
Yes.
That
And
will
also,
be-
my lord,
that, my lord,
just a minute. And also, my lord, the stoppage of increment.
I'm coming to that. You're not allowing the court
Yes.
to finish.
Yes.
The third aspect is the penalty of stoppage of one increment.
Yes,
There you have preferred an appeal.
yes.
We'll ask them to dispose of the appeal with a speaking order, reasoned order. Within how many days will you do it?
as per law, my lord, that they will do it. Lordship will give us 1 month time. my lord.
Or at 6 weeks' time, they will do
Yes.
it. If you are aggrieved, you come with by making proper grounds.
My lord.
If you are aggrieved by that order, then you come back, we'll
No, my lord,
entertain.
what I am on, my lord,
Hmm.
Rule 9, they have said that.
All right, all right. All right. Then we'll issue rule and hear it in due course. There is no other way out, Mr. Sharma.
Rule 9, they are to follow. If
All right,
they-
heard Mr. R.P. Sharma.
All these grounds have been taken in the appeal.
Huh?
All these.
No,
grounds
but
have
he
been taken in
doesn't
the-
want them, you.
No, no, no,
that would have
I'm
been better
not a
for-
question of my not wanting.
Hmm.
What I am there, while they consider my appeal, whether they followed Rule 9 or not, that should be considered.
No, no, appeal is still yet to be considered.
So totally violative of the procedure.
So you want that writ petition should be also pending? That also should go on. If you succeed there, we'll withdraw it,
No, no,
otherwise,
I have an
that
objection.
will not be
I have
possible.
an objection to that.
Mr. Sharma, that is not legally permissible
Gotcha.
and that will not be done. So you have either the option, we can ask them to consider your appeal, pass an
Yes,
order.
my submission is noted and let them consider the appeal.
Yes. If you are aggrieved, you come back,
Yes,
you come back,
yes.
right? And we'll also ask the authorities to pass an order about on the plea of regularization of.
That because of status quo order, he obtained a status quo order and after reinstatement, he has not joined. He is happy with 75% of the subsistence allowance. Enjoying 75%, not doing service. It is a loss for us also. my lord. Only after the honorable court order, he has joined. Definitely, my lord,
If
definitely.
if they don't issue release order, how can I join there? On 10th only after loss order.
I have
They-
I have records, my lord. I have records. He has received all the documents. We are not going into that. Let the appeal be. Now he will get
On
everything.
10th I was released.
No, no.
When I submitted
No,
the
no.
joining, my lord, here,
Then we'll hear the matter in due course.
Let
Today
the,
it's not possible. We
let
can't
the
hear.
appeal be,
This
let the
matter
appeal be
will-
disposed of. Otherwise,
let them dispose the appeal,
Everything-
my lord, with my submission
That's-
noted. That's all.
All right. Where is the order of penalty?
Penalty is my lord last page.
What is the page number of the last page?
My lord, page 18. In except D. Your lordship see the justification of the offer. No, a list of witnesses was given, no list of documents is given, which requires under Rule 9 mandatorily. Blatantly illegal order.
Take down. Heard Mr. R.P. Sharma, learned senior counsel, assisted by Mr. D. Dole, learned counsel appearing for the writ petitioner. Also heard Mr. D. Nath, learned senior government advocate, Assam, appearing for the respondents. Full stop. The writ petitioner is working as
Jail warden,
jail warden,
warder.
warder, W-A-R-D-E-R,
Dreadful employment.
Yes.
and posted at the district jail at Karimganj. Full stop. Earlier, by order dated
23rd May, my lord.
order dated what is the date of suspension?
Yes, same order, my 23rd May, 2022.
No, no. 2022-10-2021.
22/10/2021. That is not under challenge. 22/10.
Yes, yes.
22/10/2021. The petitioner was placed under suspension.
Page 17. Page
Thereafter,
17.
page 17.
17. Lordship.
Thereafter, a disciplinary proceeding was initiated against him
Without the
Person-
RCD, my lord.
person where to the order of penalty of withholding of one increment without cumulative effect has been imposed upon the petitioner by the order dated 23/5/2022 issued by the Deputy Inspector General of Prisons, bracket range, bracket Guwahati. Full stop. Aggrieved by the aforesaid orders, the petitioner had approached this court by filing the present writ petition. Full stop. It was also the contention of the petitioner that although he is willing to join, the authorities are not allowing him to join in his place of posting. Taking note of the said submission of the petitioner's counsel, this court had passed order dated 8/2/2023, asking the learned departmental counsel to seek instruction. First of today, when the matter is called up, Mr. Nath has produced a copy of the joining report dated 13/2/2023 pertaining to the writ petitioner to submit that the petitioner has been allowed to join as the warderer in the district jail at Karimganj. First of, if that be so, the grievance of the petitioner, as noted above, has been partially redressed. Full stop. The next issue is pertaining to the validity of the order of penalty. Mr. Sharma submits that the entire disciplinary proceeding is divorce the provisions of law, and therefore the order of penalty is liable to be set aside on such count alone. Full stop. The submission of Mr. Sharma, learned senior counsel for the petitioner, prima facie appears to be attractive. However, we find this court finds that the petitioner has submitted an appeal before the, where is the appeal?
Page 56 in the affidavit reply.
Appeal before the Inspector General of Prisons, Assam, on 22/8/2022. Under Rule 16 bracket 2 bracket close of the Assam Services bracket Discipline and Appeal bracket close Rules, 1964. Read with Rule 115 of the Rules for Management of Jails in Assam, assailing the order of penalty dated 23/5/2022. Full stop. It appears that the said appeal has not been disposed of till today. Full stop. Mr. Nath submits that if the court issues a direction, the appeal will be considered and disposed of in accordance with merit within a period of 6 weeks from the date of receipt of a certified copy of this order. Full stop. Mr. Sharma has also agreed to the aforesaid recourse subject to the conditions that the appellate authority shall consider the plea regarding total illegality of the disciplinary proceeding as well as
Particular rule 9 of the.
In para 10 of the appeal.
with reference to Rule 9 of
Para
the
10.
Rules of 1964. That apart, the petitioner be also given liberty to approach this court if he continues to remain aggrieved even thereafter. Full stop. Taking note of the submission made at the bar, this writ petition is being disposed of with a direction upon the respondent number. IG is respondent number? Respondent number?
2.
Respondent number 2. To consider the appeal dated 22/8/2022 submitted by the petitioner and dispose of the same with a reasoned order in the light of the observations made herein above. Full stop. If the petitioner continues to remain aggrieved even thereafter, it will be open for him to approach this court by filing a fresh writ petition. Full stop. Needless to say, since the petitioner has been allowed to join back in his place of posting, the authorities will also pass appropriate orders with regard to the period of appropriate orders responding to the plea of the petitioner for regularization of his services during the period of suspension in accordance with the rules. Full stop.
And the area salary also.
Huh?
And area salary.
25% area he will get.
And also release the arrears salary that may be payable to the petitioner. With the above observation, this writ petition stand disposed.
Plus, he had joined in this service on 12th. The covering letter is
Acha.
information is 13.
It shows that the petitioner has joined at Karimganj on 12 to 2000.
After he released one.
I'm asking you, do you need interest also?
Mr.
No,
Sharma
he didn't ask me, do you need an interest? He said, he want the code also.
May it please the Lord. My Lord, this is a matter where the petitioner applied for voluntary retirement. Actually, my Lord, he was posted in Silchar Medical College for quite some time. Then while he was at Silchar Medical College, my Lord, he was given a posting on attachment at Borpeta Medical College. He said, either you, on account of my health reasons, either you, modify the transfer order, or please allow me to go on, my Lord, the voluntary return. Now, what the authority did subsequently, my Lord, thereafter I did not attend duties, it's a fact, because there is a legal fiction created by this statute. Thereafter, they have initiated a disciplinary proceeding against me, and they have taken some action. That will come subsequently. If your Lordship will kindly come to my petition, page 15, my Lord. Page 14, my Lord. Page 14, para 15.
Yes.
Now, FR 56 is quoted. Any government servant may, by giving notice of not less than 3 months in writing to the appropriate authority, retire from service after he has attained the age of 50 years or has completed 25 years of service, whichever is earlier. My Lord, only requirement is a government servant is required to give a 3 months notice following completion of either attaining 50 years or, my Lord, completion of 25 years of service. My Lord, there are judgments of the Supreme Court. As far as 56C is concerned, my Lord, it has been held to be a condition of service. And my Lord, on fulfillment of the conditions envisaged by this rule, my Lord, a legal fiction is created. Now, therefore, it's end of the matter. Thereafter, what they have done is hardly matters. Now, Lord, you will kindly mark 3 dates, my Lord.
Yes.
On 29/12/2017, that application was filed, my Lord, which we have annexed. So going by FR 56, my Lord, 3 months expired on 29/3/18. And thereafter, my Lord, a show cause notice was issued on 4/1/2020. Now, question is, my Lord, if it is a condition of service, if, my Lord, I am eligible for VRS, why will you hold me, my Lord? I'll just rely on 2 judgments of the Supreme Court, my Lord. It's a very small order.
This VRS, the employee applies, that's the end of the
Yes,
matter.
that's the end of it.
No need to
No, my
accept
Lord.
it.
Unlike in case of FR 56K, in case of central government, there is an element of discretion where government's consideration is required. But as far as 56C is concerned, there is no element of discretion. That's the law. I'm placing the judgment, my Lord. It's a famous case, that Dinesh Chandra Sangma case from our state only. There are 2 judgments, small judgments, my Lord. In fact, my Lord, this was a judgment authored by Honorable Justice P.K. Goswami. My Lord will kindly come to page 447.
Yes.
FR 56C, para 13. FR 56C is one of the statutory rules which binds the government as well as government servant. The condition of service, which is envisaged in Rule 56C, giving an option in absolute terms to a government servant to voluntarily retire with 3 months previous notice after he reaches 50 years of age or has completed 25 years of service, cannot therefore be equated with a contract of employment as envisaged in explanation to Rule 119. The field occupied by FR 56 is left untrampled by explanation to Rule 19. The words in contract of employment in explanation 2 are a clinching on the point. It is the cardinal rule of construction that no words should be considered redundant or surplus in interpreting the provisions of a statute or a rule. Explanation 2 does not say an express or implied term of employment, but refers to an express or implied term of his contract of employment. If language in explanation 2 were different, namely an express or implied terms of employment instead of contract of employment, the position would have been different. Explanation 2 in Rule 119, albeit a penal rule, takes care to use the word contract of employment and necessarily exclude the two categories of employment, namely one under the central government and other under the state government. Explanation 2 only takes in its sweep the third category of employment, where relationship between the employer and the employee is one governed by contract of employment. Since FR 56 is a statutory condition of service which operates in law without reference to contract of employment, there is nothing inconsistent between Rule 119 and FR 56. The appellant had voluntarily retired by 3 months' notice in accordance with an express or implied term of his contract of employment, but in pursuance of a statutory rule. Explanation 2 to Rule 119 makes no mention of retirement under a statutory rule, and hence the same is clearly out of way. The submission that Rule 119 is superimposed on Rule FR 56 has no force in this case. The para 17 is important. The High Court committed an error of law, holding that consent of the government was necessary to give effect to the voluntary retirement of the appellant under FR 56C. Since the condition of FR 56C are fulfilled in the instant case, the appellant must be held to have lawfully retired as notified by him with effect from 2nd of August 1976. So this is the law, my lord. Now, if your lordship would kindly have a look at the other judgment, my lord. Para 5. Para 5 at page 77. The second aspect of the matter is that it has been held by a 3-judge bench of this court in Dinesh Chandra Sangma versus State of Assam, which has dealt with a perimeteria provision finding place in Rule 56C of the Fundamental Rule, where the government servant seeks premature retirement, he does not require any acceptance and comes into effect on the completion of the notice period. This decision was followed by another 3-bench judge in so-and-so, so-and-so. So that's the law, my lord. Now, my lord, they did not consider my prayer, neither they considered my prayer for compulsory retirement. Instead, my lord, on the ground of insubordination, they have instituted a proceedings whereunder, my lord, they have been dismissed from service. So this is the law, my lord.
So after 29/3/2018,
I am deemed to have been retired
you are
voluntarily.
no longer in service.
No longer in service. So that master-servant relationship does not exist. Therefore, there is no question of any disciplinary proceeding.
And what was the charge in the disciplinary proceeding?
Unauthorized absence. Because, my lord, after that, I have not gone to office. And we are not shuttlecock, my lord. We are all human beings, my lord. You'll keep me there for years together. Then you attach me somewhere else because IMC comes. You are showing, you're opening colleges after colleges. Go to one college if there are faculty in full. You go to Guwahati Medical College, forget of others. So you shift the overnight for the IMC inspection and the overnight you bring them back. They are not shuttlecock, they are also human beings. They have human dignity. So therefore, my humble submission is, my lord, here is a clear-cut case. It's an open and shut case. I don't think they have anything to say. Several times adjournment was taken, my lord. They haven't come with the instruction.
My lord, I have received the instruction that, my lord, the VRS application, and in fact, my lord, during the DP, my lord, the petitioner himself have deposed before the authority that he has not applied for VRS in a proper manner and by enclosing the required documents. And secondly, my lord, if your lordship kindly see the chronologically dates, my lord, after, because he has applied for leave, my lord, several times till the date of 18/5/2018, my lord. And those leave application also, my lord, he has not submitted in a proper format because leave applications have been submitted through the concerned principal to the office of the DME. So those leave applications, they are also, he has not submitted in a proper manner. Because of that, could not be considered, which is reflected in
But
the
have
inquiry
you
report.
informed him that it could not be considered because of this reason? Has he been informed about it?
It is not the duty of the authority to inform him that, because he knows how to.
So, but how will you know that according to you, there is some defect in the application?
But if it has not been granted, because whenever leave is granted, he will be aware of that. If it is not
All
granted,
right, you forget the leave now.
yes, my lord.
What about his argument that he had submitted application for voluntary retirement?
That initial application, thereafter he has joined in duty, and thereafter also he has applied for earned leave. And secondly, regarding the issue of voluntary retirement, I have got the deposition of the petitioner.
But
before
then
the-
you show me, you place your case. Where is the affidavit?
Yeah, my
Yes,
lord,
application is my lord.
that record I have sought for my lord. So today I will receive the record. I will produce the
Page
records, my lord.
29, my lord.
I have sought for the records, my lord.
A request for posting so and so. That, sir, I was transferred from SMC to Guwahati by letter dated so and so, and I joined GMC on 23rd of December 2016. As per the order, I have to strengthen the cardiology at FAMC Borpeta. Accordingly, I submitted detailed plan for the same. As my daughter was appearing in HSLC examination in March 2017, it was not possible for me to work at Borpeta. Subsequently, due to my familial problems and my physical illness, I took earned leave and medical leave. That, sir, as my children are studying in Silsar, I am having lots of medical problem, so and so, so and so. It is physically not possible on my part to work at FAMC, where there is no cardiology department and no subordinate staff. Considering these facts, I request you kindly to revise the order and place me either at SMC or GMC in the interest of public service. If that is not possible, please allow me to go on voluntary retirement.
Acknowledged police case 46, part of the
My lord, it was filed on 29.
My lord, if your lordship will kindly come to page 46, my lord. And in the inquiry, my lord, the inquiry officer has brought out this aspect. At page 46, it's part of the inquiry report, my lord. Somewhere in the middle, this sentence starting with Dr. Sharma has submitted, page 46. Somewhere in the middle, my lord, Dr. Sharma had submitted, has the lordship got it, my lord?
Yes.
Dr. Sharma had submitted an application dated 29/11/17 to the government to transfer him to SMCH or GMCH or grant voluntary retirement. So even in the inquiry, my lord, this aspect has come out.
impugn order, page 51.
And page 51 impugn order, my lord. Kindly come to the fifth subpara. Whereas on examination at page 51, whereas on examination it was found that the representation dated so of Dr. Prabhas Chandra Sharma did not contain any new facts which warranted a review of the penalty decided to be imposed upon so. And above that, whereas Prabhas Sharma by representation dated 17/5/21 request government kindly to grant him earned leave, etc. and voluntary retirement from service. So the appointing authority is conscious of the fact that my application is pending.
My lord, here the application that has been referred, my lord, annexure C page 29, that was filed on 29/12/2017. And his prayer was that kindly to revise the order and place me either at SMC or GMC. And thereafter, my lord, on 16/2/2018, he joined back at GMC, my lord. So that application gone, my lord. Because his priority was either to allow him to join at GMC or SMC or to grant VRS. Although VRS was the application was not filed in a proper manner, but after that, on 16/2/2018, he has joined back in GMC, my lord. And in during the DP, my lord, he himself stated before the authority that he has not applied for VRS by filing proper application in a proper manner, my lord. That record I have sought for, my lord.
So what is the penalty imposed?
Penalty unauthorized
Dismissal from service.
dismissal from service.
For unauthorized absence.
Unauthorized absence, my lord.
Get the record and let us pass the judgment.
Yes, my lord.
When do you will do it?
Next week, my lord.
Shockingly disproportionate to say the least.
Yes, my lord. That your lordship.
These are family circumstances. People are entitled.
Yes, my lord.
You may or may not consider, but people ask for leave, you should.
No,
and
that
throw them
part
out, dismiss them.
regarding the disciplinary proceeding or that part your lordship may examine. But GRS application, my lord, it was not filed in a proper manner, so it was not considered. That is the admitted.
So
fact.
what happens if we set aside his order of dismissal? He will be treated to be in service. You have to pay him the salary. What do you want to do? You want to pay him retirement dues or you want to pay him his salary? You get your officers to give you the instruction. We'll take this up matter on Tuesday.
Okay.
As a fixed item. Get the records and get.
Thursday, my lord.
Why?
My lord,
Thursday is auspicious.
Tuesday, I have a matter.
That's all right, Thursday.
Okay.
But you please get that instruction also. Supposing after going through the record, this is a tentative view of the court, that forget everything else. You can't treat a doctor like this. They are not to be treated like this.
Yes, my lord.
You may or may not accept their leave application. That is another thing. But dismissal from service.
Children
Yes,
appearing in matric or class 12, these are very important for any parents.
Problems which the department has to deal with. I don't say that the department doesn't face difficulties. I'm not saying that. But dismissal from service on this ground, these are senior doctors. He's a senior
And
doctor.
you,
Is it?
if you are giving the responsibility of setting up a, department in a particular college.
All right, that is another matter. We are not getting into all these things. Only thing is, things have to be balanced out, Mr. Moran.
Your lordship into disproportionate.
Oh, shockingly
Yes,
disproportionate.
my lord. Yes, my lord. I will obtain.
So, subject to what we see in the record, we'll set aside this order. Now, what happens? Will you allow him to go on voluntary retirement? Or should we direct his reinstatement? Would you like to be on voluntary retirement with
Yes.
effect from?
Yes.
Huh?
Let them have both the instructions.
Let both the instructions. Let him go on voluntary retirement with effect from that day.
29th, yes.
Yes, my lord. I will obtain.
Open instruction.
Deep.
Thursday. Biraswati were a fixed item, fixed part and matter.
Publishing.
Item 23.
May I please, lordship? This is my lord regarding selection and appointment, my lord. Lordship, in this case, I have
Hey,
received
one
the
minute.
paravise comment to put this. The release published on 21/1/2021, my lord, but in the name of verification, my lord, till date, my lord, they kept.
Lordship, I have received the paravise comment to file our affidavit, Lordship.
Can you come back again? What are you trying to say?
Release published on my lord 21/1/2021, my lord,
Hmm,
selecting the petitioner for the post of SSD, my lord.
hmm,
But till now, my lord, order of appointment has not been issued, my lord.
hmm.
They say, my lord, some verification is required, my lord. The verification is required.
What is your
Awaiting
instruction?
CFL.
What is your instruction?
Lordship, I am awaiting the CFSL report, Lordship. This handwriting was sent to the CSFL
Why?
because it was found
He's
doubtful.
accused in any.
No, Lordship, his specimen signature does not meet with the written in the answer papers, Lordship. So it was doubtful who appear in the examination and the
When
signature.
did you send it?
Lordship, it was sent on 15/2/2021, Lordship. Then we have sent our reminder on 9/6/2021. Also, as also 21/6/20, we are awaiting this,
Then you keep waiting, let him serve in the meantime.
Lordship.
See, handwriting specimen signature, it takes more than
There-
2 years.
Lordship, there are 212 such candidates, Lordship. So we have sent all of this to the CF7, Lordship.
Is the CSFL a party here?
No, no, Lordship.
You plead, otherwise you can't get any relief. Mr. H.R. Khan, Ahmed, learned counsel for the petitioner praised for and is granted leave to implead the Central Forensic CFSL,
CFSL.
Central Forensic Science Laboratory as a respondent in this case. Mr. S.S. Royal and CGC submits that he has received some instructions and therefore be given how much time?
Lordship, 3 weeks, Lordship.
3 weeks time to file affidavit. let the matter be listed. You implead them, we'll ask them why they are taking so long. Yes.
Item 24.
Yes, but the last occasion also, my lord, they took time for filing affidavit. Matter relating to my lord compulsory appointment. The prior of the petition was rejected on the ground of local language issue. Is a postal department of Gram Sevak man. So on that point,
They were rejected on what ground?
on local language issue, my lord, language issue. Under the
Local
notification-
language issue.
Yes, ma'am. Under the notification, petitioner should know the local language. The petitioner is a, he hails from the locality, my lord, of Karimun district.
Hmm.
And his mother tongue is Bengali. He read up to class 9 Bengali language, my lord. He knows the Bengali, right Bengali. Without taking any interview, they are saying that, my lord, he's a higher secondary pass, my lord, from CBSE course.
Where is the order rejecting?
Order your lordship will find page 30. You could order.
What is the CC? What is the CC meeting?
CC, my lord, that is Committee for Compulsory Engagement, my lord.
Hmm. So what is local language issue? You are appearing for whom?
A guy, lordship.
Hmm. What is the local language issue here?
Lordship, I'm not aware.
In
of the
Borakbili,
facts
my
of-
lord, as per notification, it is Bengali.
No, that's right, but what is the issue? He
Issue.
belongs to that part of the country.
Yes, my lord.
Then
And also,
what is the issue here?
I am submitted also, my lord, my 9% certificate and mark sheet. There, I have a Bengali subject. I passed the Bengali up to class 9. If I have, there, my lord, has. They also asked for the certificate, page 33, my lord, you will find. Class 9% certificate that I have submitted, but that was not considered. That I have submitted, my lord, by my page 34 and 35. That is pending, my lord. That was not considered, my lord. Yes, one notification, lordship will find page 37.
What is the notification of 2015? Where is it?
Yes, my lord, and now they are 2015, my lord, there is no such language issue. It is, my lord, that page you will find notification page 26. my lord. 15 notification. As per that notification, there is no such, but later on in 2019, page 37, another notification came up. And as per that notification, from Assam district in Borakbili, the petitioner should know the Bengali language.
That is in the 2019.
19, my lord. So now the 19 will govern. Page 37, your Lordship.
Yes, what do you have to say?
Lordship, we need some time to file.
No,
an
no, I'm
affidavit.
disposing on this matter is not that. Yes, heard Mr. S. Not learned counsel for the petitioner also heard Miss.
M. Burman.
I write your name.
Lordship, give us some time to file an
No, no.
affidavit.
These are.
We have recently received an
Hey,
instruction.
Gayan,
Lordship.
what is your instruction?
Lordship, we will file an affidavit, Lordship, on the last
Hey,
occasion.
Gayan, learned counsel, learned CDC appearing for the, what is your instruction? Tell me.
Lordship, on the last occasion, we have not received any
I am not
instruction.
granting you time. These are matters which cannot gather dust in the court like this. You did not file affidavit, you did not file, you missed
Lordship,
the
give
bus.
us one chance.
Again, learned counsel appearing for the respondents, first up. The writ petitioner has approached this court by filing the instant writ petition, assailing the order dated 29/2021, issued by the superintendent of post offices. That is the respondent number 5 here, rejecting the prayer made by the petitioner for appointment on compassionate ground due to within courts local language issue, unquote. Full stop. The facts of the case, briefly stated, are that the father of the petitioner was serving as a Gramin Dak Sevak, bracket GDS, bracket close, under the postal department in the Anipur, ANIPUR post office, which falls within the Karimganj district of Assam. First up, the petitioner's father died in harness on 28/8/2016. First up, since he was the sole breadwinner of the family, the petitioner submitted an application for appointment on compassionate ground, and the same was also considered by the Committee on Compassionate Employment, bracket CC. Is it Committee on Compassionate Employment?
Engagement, my lord, engagement.
Committee on Compassionate Engagement, that is CCE. First up, but the application of the petitioner was rejected on the ground that there were local language issue within courts. It is nowhere mentioned as to what was the local language issue. First up, therefore, by referring to the materials available on record, Mr. Nath has argued that the local language in Karimganj district is Bengali, and the petitioner also belongs to the Bengali community. First up, he had also submitted school certificates before, along with his application, to show his proficiency in the Bengali language. First up, under the circumstances, it is not known as to why the petitioner's candidature was rejected on the ground of local language issue, again within course, local language issue. First up, Mr. Nath has also drawn the attention of this court to the office memorandum dated 4/6/2019, which lays down that the local language for the postal circle of the 3 Barakvili districts, including Karimganj district, is Bengali. Full stop. According to Mr. Nath, as per the earlier circular dated 2015, there was no local language criteria, and the petitioner's case ought to have been considered in the light of the circular dated 2015. First up. However, even as per this office memorandum of 2019, the petitioner meets the requirement of local language, and therefore the impugned order is wholly untenable in the eye of law. First up, the learned CGC has submitted that some more time be granted for filing affidavit. However, the learned departmental counsel has failed to explain as to the purport and intent of the impugned order dated so and so. First up, under the circumstances, this court is of the unhesitant opinion that there was no proper consideration of the candidature of the petitioner by the CC for appointment on compassionate ground. Full stop. It is to be borne in mind that appointments on compassionate ground are made under special circumstances so as to give relief to the family of the deceased employee. Full stop. Therefore, causing undue delay in finalization of such process, that too on grounds which are not substantiated by the materials on record, does not comment for acceptance by the court. First of, For the reasons stated herein above, the order dated so and so is hereby set aside with the 29/2021. The respondents are directed to consider the candidature of the petitioner afresh and pass appropriate order therein after taking into account all documents, including the school certificates submitted by the petitioner, full stop. An order on the candidature of the petitioner be passed within a period of 6 weeks from the date of receipt of a certified copy of this order. The writ petition stands disposed of. Yes, next matter, please.
Obliged.
Item 25.
My lord, this matter have received instruction, my lord, the transfer order, which is under challenge, my lord, we have withdrawn the order on medical grounds, my lord. So at the moment, my lord, we have.
Heard Mr. A. Tawildar, learned counsel appearing for the petitioner. Also heard Mr. H. Gupta, learned CGC appearing for the respondents, who has produced a copy of the communication dated 31/8/2022 to submit that the transfer order of the petitioner has been withdrawn by the authorities on medical ground, and therefore nothing survives for adjudication in this writ petition. First up, Mr. Tawildar has also confirmed the said position. In view of the above, by retaining a copy of the written instruction dated 31/8/2022, this writ petition stands closed.
Obliged.
Item 26.
May it please the Lordship. Lordship, this matter relates to compassionate appointment, wherein the case of the petitioner was forwarded by the DLC against existing vacancy, but the same was dismissed by relying on clause 1 of the office memorandum dated 1/6/2015, which states that 3 years balance service should be there. But that has now been set aside by this honorable court as unconstitutional. And therefore, similar matters have been remanded back to the SSC for a fresh consideration.
Order. The copy. 1646. It is single verse, no? Single verse, yes. My lord, this issue, the similar matter is fixed for 22/2/2023. We will also go through it, my lord. This issue will, I will address it, my lord.
No, let me see if the
Lordship will
notification has been set aside. You have to address only that side, court number 1, not here.
page number 37.
Yeah, you have to address it in a different address.
Yes.
This will be the wrong address. for the
So, similar matter is
Number of
pending, my lord.
petition, page 37, your lordship. The penultimate paragraph
Page 30.
7. Paragraph number 19, recently it has been submitted. May I read your lordship? In view of the above, therefore,
No,
this
1 minute, page 37.
37. Paragraph
Yes.
19.
Hmm.
In view of the above, therefore, this court answers the issue number 1 to the effect that the clause 1 of the OM dated 1/6/2015, whereby the dependent family members of government official who die in harness having less than minimum 3 years of service being not eligible as per the said office memorandum is unconstitutional, being violative of Article 14, and accordingly struck down to the said extent. And thereafter, number of cases matters remanded back to the SST for first consideration. And that was the ground for rejection of my case.
All right, Mr. Chutia. You argue it, but somewhere else.
No, my lord, no. One thing, another is, but I don't know. Order passed by the Lord single judge, my lord. Lordship is holding this. My lord.
No, it has been struck down.
That's what, my lord.
Let us see where is the order rejecting your case.
Lordship, rejecting at page number 36.
Page number 36.
Yes,
At it is
less than 3 years of service.
Where is it? Where is it?
95, your lordship, if it is legible. I have also given type copy.
Hmm.
Abul Fazal Jahangir was less than 3 years of service remaining at the time of.
Yes. So we'll send it back and get a stay order from the.
Only my humble submission for lordship, my lord.
Hmm.
This aspect of the petitioners, my lord, is recommended for the sectional assistant. So far, my knowledge goes, my lord, to the post of sectional assistant, petitioner must be at higher secondary science.
Sectional
No, but
assistant.
that's not the reason.
That is ignored in the affidavit also, but I know well.
But in that aspect also they will see. They
Rejected
only
again on
say
that ground.
3 years balance is not there. That's only they,
All right,
Other consideration they may see.
yes.
the qualification should be my lord proper. So the sectional assistant, my lord, is a technical post. There must be a science has to be passed.
All right, this is item number.
That may be noted, my lord.
26. Heard Mr. M.H. Lashkar, learned counsel for the petition. Also heard Mr. T.C. Chotia, learned additional senior government advocate Assam, appearing for the respondents. Full stop. The petitioner is aggrieved by rejection of his prayer for appointment on compassionate ground against a grade 3 vacancy, merely on the ground that less than 3 years service was remaining at the time of death of the father of the petitioner. Full stop. The facts of the case, comma, in a nutshell, comma, is that are that the father of the petitioner, late Joinul Huda Chaudhary, was serving as a sub-engineer, grade 1, in the office of executive engineer, comma, PWD Rural Road Division, comma, Hailakandi, who died in harness on 3/4/2016. Full stop. Since Joinal Huda Chaudhary was the sole breadwinner of the family, hence, in order to tide over the financial crisis, the writ petitioner, being his son, had made an application for appointment on compassionate ground. Full stop. The application submitted by the petitioner on 9/5/2016 was considered by the DLC Hailakandi, and his name was also recommended for appointment in the post of section assistant. Full stop. However, the SLC, comma, in its meeting held on 31/12/2018, comma, had rejected the case of the petitioner on the ground that his father had less than 3 years of service at the time of his death. Full stop. The aforesaid conclusion was apparently drawn by the SLC by relying upon the office memorandum dated 1/6/2015, which provided for such a recourse. Full stop. However, today when the matter is called up, Mr. Lashkar has placed a copy of the judgment and order dated 30/1/2023, passed by the learned single judge of this court in WPC number 1646 of 2021, and the batch of connected 1646 of 2021, to submit that the OM dated
Clause 1 of the.
OM dated clause 1 of the office memorandum dated 1/6/2015, which had which contained a provision permitting rejection of applications for compassionate appointment if the deceased was left with less than 3 years of service on the date of the death, has since been set aside, and several cases have been remanded back to the SLC for reconsideration. Full stop. As such, a similar order be passed in this case as well. Full stop. After perusal of the judgment and order dated 30/1/2023, I find that clause 1 of the OM dated so and so, it is
1/6/2015.
1/6/2015 has been struck down by the court by holding the same as unconstitutional. If that be so, there can be no doubt about the fact that the petitioner's case would call for reconsideration. Full stop. However, this court finds force in the submission of Mr. Chotia that since the petitioner is applying for a grade 3 post,
Sectional assistant.
hence his candidature would be subject to fulfillment of necessary educational
Qualification and other.
necessary qualification and other criteria for appointment to such a post. Full stop. In view of the above, this writ petition stands disposed of by providing that the SLC may consider the case of the petitioner afresh in the light of the observations made herein above and pass appropriate orders.
I'm deeply obliged.
You are there? Mr. P Naik and council for 2, 4 and 5. Mr. Chutia for 1.
I am for 1, 3 and 6.
1, 3 and 6.
In the next SSC.
No.
Obliged. May it please your lordship.
Lordship, I paid for 2 weeks time to file my affidavit. Lordship, the instructions.
What
are
is the
awaited,
issue?
Lordship.
My lord,
The application for VRS.
petitioner filed an application for voluntary retirement in 2007, my lord.
Hmm.
That was not accepted nor rejected.
Hmm.
Ultimately, they have initiated disciplinary proceedings after 4 years, and it was not concluded up to 16 till file the
You
petition.
file affidavit,
He
do
was
whatever.
unauthorized.
I'll dispose of this matter on Thursday.
Lordship,
Is another
it's
matter similar.
My
matter.
Lordship, a week's
And-
time will be required, Lordship.
No,
The
no.
instruction is to
No,
come
no,
from
no.
Dibrugarh, Lordship. He was unauthorizedly absent
My
from
lord,
2002, Lordship.
I have.
And he doesn't qualify for voluntary retirement, Lordship. He neither has 15 years of service, Lordship,
Hmm.
nor he has 20 years of service and 50 years of age.
All right, you file it by Thursday.
Lordship, 1 week will be required,
Thursday,
Lordship. I
Thursday.
have not received my instructions.
My lord, disciplinary proceeding has been quashed by this honorable
Lordship,
court, my
again, I
lord.
have to take time.
So,
on Thursday, Lordship.
question of unauthorized absence now gone, my lord.
I have
By
not-
virtue of this honorable court's order.
27th February as fixed item. Both sides in Namdevo. And on the request of Ms. R. Bora, Departmental Council, let this matter be listed on 27 to 2023 as a fixed item, so as to enable her to obtain instruction and file affidavit.
Okay.
May I please, lordship?
Yes,
My lord, in this case, my lord, the petitioner was deprived for his promotion to the post of SI of police, my lord.
Hmm.
And what happened, my lord? His juniors have been promoted on 23 to 2022, my lord. Serial number, page number 25, my lord. Thereafter, my lord, on his, he inquired into the with the department, my lord, he has come to know because they have formulated a draft service rule which provides, my lord, that after procuring a training program, which is essential for the post of higher post of SI of police, my lord. After procuring training program, your seniority will be counted from the day of procuring the training pass certificate, my lord. And on that ground, they have made me a junior and of my colleagues, my lord, who are actually junior in the graduation list, and thereby they have deprived me, my lord. In this regard, my lord, the Honorable Supreme Court has laid down the settled law, my lord, which says that even if higher qualification is required during the service period, my lord, the incumbent procures that degree, my lord, that will not be the basis for determination of the seniority of the that
which department?
police department, my lord.
APRO, you have filed affidavit, my lord.
They have filed the affidavit, my lord. I have filed the reply also, my lord.
All right, so we'll dispose it of today.
Lordship can dispose of
All right, you wait, let other matters.
at 2 p.m.
No, there are other admission matters. Serially will take up.
Yes, lordship.
No, orders.
For orders, I can 29. May it please, your lordship.
Hmm.
Your lordship, kindly there is Lazima court order dated 6/2/2023, lordship.
Seven and 10 service complete. What about the others? Who is appearing for the other? You are for whom?
The respondent number 2.
2 and
Respondent number 2. 1 and 2.
you?
I'm for 3, 4, 5 and 6.
3, 4, 5 and 6.
Yes.
And what about 8, 9, 10, 7, 8, 9, 10, 11?
Private respondent.
7 and the service.
All right, you take down hard, Miss.
I teacher, your lordship. I teacher.
I could tell any counsel for the petitioner also heard Miss S. Burwal, and Government Advocate Assam appearing for the respondent numbers 1 and 2. And Miss R. B. Boral and Standing Counsel BTC for respondent numbers 3 to 6. None has appeared for the, office note indicates that service of notice is complete on respondent numbers 7 to 11. However, none has appeared for the said respondents. Be that as it may, since the writ petition is ready as regards service, office to list the matter for admission in usual course.
Item 30.
Yes, who is appearing? Anybody appearing for item 30? None appears for the petitioner on call. Are Mr. S. Datta, Lanet, SC Revenue Department, Assam, and Ms. S. Burwa, Lanet, Government Advocate, Assam, appearing for the respondents. Perused office note dated 7 to 2023, which indicates that fresh steps have not been taken by the petitioner till date. Be that as it is, for ends of justice, 2 weeks further time is granted to the petitioner to take steps, failing which consequential orders will be passed. Let the matter be lifted accordingly.
Perhaps matter may become impactuous also, because as per notification dated, attaining the age of retirement is 65 years. At the time of filing of this petition, his age is 56 years. Maybe it will become impactuous.
Why?
65 years is the
How many years? When was this matter?
14 matter, 14.
So 9 years. What is the relief once?
Claiming for appointment in the court of Gaon Buhar. Appointment of Gaon Buhar. Maybe.
None appears to the writ petitioner on call. Mr. So-and-so for respondent numbers for the Revenue Department and Ms. S. Burwal and the Government Advocate Assam are present on behalf of the respondents. This writ petition was filed on 11/6/2014, seeking a writ of mandamus for appointment of the petitioner as a Gaubura, is it?
Yes, sir. Gaon Buhar, Ingikharia village, Sonitpur district.
Gaubura in the Tini Kharia, TINIKHRIA village, under Tejpur Revenue Circle in the Sonitpur district. First time. Since then, nearly 9 years have passed. First up. At the time of filing of this writ petition, the age of the petitioner was 56 years. Since the retirement age of a Gaubura is 65.
5 years.
65 years. Hence, as on date, the prayer made in the writ petition cannot be considered by the court. Full stop. Moreover, I find that the petitioner's counsel has also failed to take steps as directed by the court. In view of the above, nothing survives for adjudication in this writ petition. The matter is accordingly closed.
Obliged.
Item 31.
In this case, when the office note, it is recorded that the petition, the respondent number 3 has not filed any ukal number nor any.
Who is the respondent number 3?
Notice was issued. None has appeared for him. Some time may be given to him, I know. A government, the Sunday Council may take instruction.
What is the order?
Order page, operative portion page 13, my lord. So it's para 6.
In view of the above, the order of suspension contained in notification number so and so is liable to be interfered with, which is accordingly done. On the setting aside of the order of suspension, even the respondent authorities shall immediately take back everything was done. But here the service benefit was directed to be given. But the service benefit includes the promotion, my lord, during the period. That has not been done.
That you have to file a writ petition, not in the contempt case. Your client has been reinstated.
Reinstated, he is
Yes.
getting pension also, but the service period,
Ah.
the promotional.
That cannot be handled in a contempt case.
Service benefits includes the attachment.
All right, but that declaration has to be made by the court. It can't be done in a
My
contempt
lord,
case.
I may be.
Yes. We'll close it, but you can file appropriate.
That liberty may be.
Yes. 31, you right, heard Mr. H.K. Mohanty, learned counsel for the writ petitioner. Also heard Mr. H. Salia, learned counsel appearing for the respondent, alleging willful disobedience of the order dated 26/6/2015, passed by this court in WPC number 7050/2023. This petition has been filed. First up, according to Mr. Mohanta, in terms of the order of this court, the petitioner has already been reinstated and his pensionary benefits have also been paid to him
A portion has been left, my lord.
by leaving a small portion of gratuity. However, Mr. Mohanta submits that in terms of the court order, the petitioner was entitled to all benefits, including the benefit of promotion, which was denied to him. Full stop. After reading the order dated 26/6/2015, I am of the opinion that the aforesaid aspect of the matter, if at all, can be subject matter of adjudication in a writ petition. Full stop. However, no such observation or direction can be issued in this contempt case. As such, by granting liberty to the petitioner to file appropriate proceeding, this contempt case stands closed. Yes. Yes.
Item 32 and 33. May I please, Your Lordship? My lord, regarding item 33, my lord, in fact, petitioner was paid, my lord, pension, my lord. Item 33. Item 32, my lord. A respondent number 6 was directed to.
33 has become in.
My lord.
We'll close it first. Yes. You take down, heard Mr. M. Islam, learned counsel for the petitioner also.
Well, I am for the respondent number 4, but we are no longer in the post, my lord. The director of the pension.
Achha, all right. What is your name? You're Mr.
A. Boro, madam.
A. Boro.
Yes, on behalf of Mr. Ikene.
Learned counsel is present on behalf of respondent numbers
4.
Respondent number 4. Mr. Islam submits that the pension of his client has been paid in compliance with the court order. If that be so, nothing further survives in this matter. This contempt case is accordingly closed. What is the section in item?
Regarding item number 32, my lord, respondent number 6 was directed to be implemented, my lord. In the meantime, Mr. M.G.K. Bhanu was retired. And respondent number 3, now he holds the task as, my lord, respondent number 6, the principal secretary. So, my lord, I may be allowed to issue notice, my lord, since he has already implemented here in this case, my lord, and file affidavit also. So, he has sufficient knowledge about the judgment, my lord. So, for
who is respondent number 3?
6, my lord, Mr. M.G.K. Bhanu, my lord, who is already retired, my lord. And Mr. J.B. Ekka, respondent number 3, presently hold the charge, my lord, as principal secretary.
So who is appearing for them?
Respondent number 4 is the director of the pension. He's the HI from the service. And now the new incumbent is joined. So we have no longer.
What is the prayer here? Pension,
Pension, my lord. Kindly see, my lord, affidavit filed by, my lord, respondent number 3.
Mr. Gogoi, are
I
you appearing?
respondent number 8, my lord. Finance department. He was the then commissioner of finance department. He's not there now.
So what can be done?
The issue is, my lord, regarding granting of pension to the, my lord, provincialized employees of the Panchayat department. That issue is directly dealt by the administrative department, that is the PNRD department, and the, my lord, pension department. Finance has no role as of now, my lord.
You may be right, but this is creating a menacing proposition. How contempt now, they file contempt, then in 6 months, everybody changes. Another, by that time, that process is done. Somebody else comes in. They are running from pillar to post for their pension. All the Panchayat and Rural Development Standing Council, call it. Mr. Gogoi, you please be here for the 10 minutes. Call him, call Mr. S. Datta.
Item 34.
May I plead your lordship? There are some problems in taking steps, my lord, in this case. My lord, what happened, my lord? In the present repetition, the respondent number 7, who has already changed the selection of respondent number 6 in a different repetition, my lord. And there is an order of the Honorable Court 22/6/2017. 22/6/2017.
Yes.
The last part, it was ordered that the present writ petition be tagged along with WPC number 3780/2016.
Yes.
My lord, somehow the case is segregated. And kindly see order of the 13/9/2019, my lord, in which direction was issued to serve a copy of notice to respondent number 6.
Achha, now there is an order to tag this matter along with WPC 3780, but it has not been done.
My lord, the other case is not in the list today. And so far respondent number 7 is concerned, my lord. But respondent number 7 is concerned, my lord. Just a minute. My lord, there is an office note, my lord, 6/2023, 6/2023. It is reflected that service completed on 1, 2, 3, 5, and 6, my lord. And so far respondent number 4 is concerned, Dr. Shamedur Rahman, APSC selection committee member, my lord, his name may kindly be dropped, my lord. No address is found, my lord. He was in jail. Thereafter, where he has gone, we do not know. And so far respondent number 7 is concerned, we have issued notice, my lord. Neither AD card has returned back, nor answered notice has returned back, my lord. Kindly allow us to take a registered post along with Dusty, my lord.
Yes, that may be, that was I was supposed to point out, there is an order of the Lavazima court to submit notice on respondent number 7 in the proper address number. That is the order, my lord.
My lord,
6-2.
My lord, so far respondent number 7's advocate, Mr. Yuke Nair, he is appearing in the other case, my lord. Today I asked him that please provide me the address. He said that whatever address in the repetition is the address.
All right, your problem will be solved. Let us get both the repetition listed together. Then your problem will be solved.
Number 1 and number 2, I will be allowed to take fresh steps on respondent number 7 along with Dusty.
Oh, let him appear, then we'll ask him to accept notice for respondent number 7. Why do you want to spend money?
Yes, my lord.
Huh?
I have served a copy of the repetition to Yuke Nair also, my lord. But he is not accepted.
On the request of Mr. S.S. Goswami, learned counsel for the petitioner, the name of the respondent number 6 is hereby deleted. Is hereby struck up from the array of parties.
Respondent number 4, my lord.
Respondent number 4.
4.
Achha, 4 is hereby deleted, struck up from the array of parties. Office to make necessary endorsement in the cost title. In view of the order dated 22/6/2017 passed by this court, register to risk this writ petition along with WPC number 3780/2016.
My lord.
After 3 weeks.
My lord.
You are there, Mr.
I got a respondent number 3.
Mr. T.J. Mahanto, and senior counsel is present. There for respondent number 3. Mr. B. Gogoi for
Order
respondent.
official health department.
Standing counsel, health department for the official respondent. Miss R.B. Bora, you are also there? No. All right.
No problem.
Timing matter item 32.
Orders over. Finish orders. Which PNL? Finish the orders first.
Item 35.
Well, this is the contempt, my lord. Non-compliance of the order dated 9/11/2018, my lord. The order starts from page number 18 and the relevant portion is page number 22, my lord. Paragraph number 7. May I read, my lord? And accordingly, the present writ petition is disposed of
with the direction to the respondent authorities, more particularly the respondent number 4, to implement and execute the said government order dated 20/2/2017 in terms of the memorandum of understanding arrived between the parties on 12/7/2011, which exercise shall be undertaken by the respondent authorities, more particularly the respondent number 4, that is BTC, my lord, within a period of 6 months, my lord. Now, the 20/2/2017, that the post creation order is at, my lord, page number 15, my lord. The government of Assam has created 28 numbers of posts for the ITS Salakati Kokraza, my lord. And the direction was clearly, yes, there, the BTC to implement this order, my lord. There is an MOU, my lord, between the parties, between State of Assam, BTC, and the NTPC, my lord. Page number 12, paragraph number 4. Merit, my lord, paragraph number 4, my lord. After
Which
the
page, which page you are reading? Paragraph number?
Paragraph, page number 12, my lord.
Yes.
Paragraph number 4. After construction of ITI is completed by the third party, the same shall be handed over to the second party. The second party shall appoint engaged instructor and staff, other staff as per the norms, and shall bear all the recurring expenses such as payment of salary and others administrative expenses for running the institution. There is no financial implication on the part of the first party in terms of the creation of posts, maintenance of the institution. This is the MOU that is signed on 12 July 2011, madam. And we have to no new review of the MOU is there, madam. But in the meantime, they have filed affidavit where they got the new review, madam. That is incomplete.
Ms. Bora, what do you have to say?
Lordship, very sorry to say, Lordship, the inability of our part, that memorandum settlement is done wrongly actually. We have no financial power at all. So we have as per paragraph 16 of that MOU, there is a clause for review the terms and conditions if desired by the parties. We send this MOU, but government of Assam signed.
Yeah, but then have you sought review of the court order?
Yeah, a review order was not, yes, review order was not our favor.
Or review has been dismissed?
They have filed against
Not dismissed, review order has been annexed in my affidavit in opposition. Kindly tell you.
They filed review petition, madam, against the order dated 9/11/2018. That is not being considered by the honorable court.
Observation has been made by the made in the review petition. Kindly peruse page 39. Until and unless any clarification is issued by the state government owing financial liability in respect of the creation of post in ITI, Kalagati under MOU, the ongoing discussions stated to be taking place between the state government and the BTC cannot be considered to be a ground for review the court's order. It is only when the state government assures the BTC authority that it would take the financial liability in respect of creation of the aforementioned 28 posts or necessary changes are made in clause 4 of the MOU in terms of the clause 16. It cannot be construed that the BTC authority are not liable for financial implication in respect of the creation of the aforementioned post. Accordingly, for the reasons discussed above, the review petition is closed with liberty granted to the review petitioners to approach this court again if necessary. In the event of review of the MOU or entering into a fresh MOU as per clause 16 of the MOU, resulting into change of position with regards to the financial liability in respect of creation of aforementioned 28 number.
No, but then if the order remains, then you have to comply with it.
Yes.
We are waiting. for-
Yes, Mr. Boro, what to say? They don't have the power to do it. How can they?
Madam, they have signed this MOU earlier, madam.
Hmm.
As per this MOU, they are taking all the expenses, they will bear all the recurring expenses, madam.
Mistake
Therefore,
has
A
been
plus
done
here.
by our authority actually, Lord. But we trying to rectify, but Assam woman is not cooperating with us.
Then you pass an order. You inform him by an order. Otherwise, we can't help it. We have to proceed with the matter. These are all internal dialogues. It's not going to work out. You have to tell us why you cannot comply with the court order. Communicate to him.
Yes.
Within 2 weeks, you communicate. If the order is found to be okay, then fine. Otherwise, if we find that there is something, then we'll proceed in the matter. All right. Heard Mr. A. Boro, learned counsel for the petitioner. Also heard Ms. R.B. Bora, learned standing counsel BTC, who submits that the BTC authorities do not have the authority to comply with the order of this court, and therefore she be granted 2 weeks time so as to enable them to communicate the reasons thereof to the petitioner. In view of the submission made by Ms. Bora, this matter is adjourned for 2 weeks. This again as a fixed item after 2 weeks.
Deeply obliged.
That will fix.
Fixed item after 2 weeks, you count the date?
Deeply obliged.
47.
Last occasion it was listed before your lordship. Rightly or wrongly, they have passed some order. So I will not get anything in contempt order.
Mr. T.J. Mohanto, learned senior counsel for the petitioner, submits that some order has been passed by the authorities pursuant to the
Kindly, my lord.
court's order, and
Order
therefore,
dated.
Order dated 12/12/2022.
therefore he be granted liberty to challenge the same by filing appropriate petition. Mr. R. Dhar, learned counsel, appearing for the respondent number
Respond number 10, my lord.
10, has produced a copy of the order dated 12/10,
12/12/22.
12/12/2022, passed in terms of the order of this court. Full stop. Mr. P. Nayak, learned counsel, is present on behalf of respondent number
2 and 7.
2 and 7, and Mr.
For respondent number 9.
A. Gayan for respondent number 9. Taking note of the submissions made by learned counsel for the parties, this case stands closed by granting liberty to the petitioner to challenge the order dated 12/12/2022 if so advised.
Must.
Item 36.
Please, your lordship. Lordship, it is regarding the revision of the pension, your lordship, of the petitioner. There's a direction to revise the pension, but till date the same is not done. In the meantime, your lordship, the respondent has filed an affidavit, and they have annexed a communication, which is at page 9 of their affidavit, your lordship.
Where is the direction? Where is the order?
Order dated, your lordship, 14/1/2019, your lordship.
So you have filed the direction is only to consider representation.
Yes, your lordship.
Then what happened? You have filed a representation.
No, lordship, it is regarding the revision of the pension, your lordship, and they.
That's correct. You are alleging disobedience of the order dated 4/1/2019.
Lordship.
So the learned judges said you are to you have addressed a representation to the accountant general.
Lordship.
So that accountant general was asked to dispose of the representation.
Lordship, that is done, your lordship.
That is
and-
done.
Yes, your lordship, but they are now handicapped because the respondent here, they are not submitting the service book, your lordship. In the meantime, they have, your lordship may kindly come to page 9 of.
Who
the
is not
affidavit.
submitting the service book?
The PWD, your lordship.
Lordship, he is getting regular pension, he revised scale, Lordship.
Hmm.
Lordship, even the treasury officer has forwarded to be the bank statements also.
Hmm.
That is this regularly deposited in the.
So
bank.
accountant general has passed
Yes,
some order.
Yes, Lordship.
Lordship, there's a communication, your lordship, recent communication.
Let us see what is the communication.
May 2022. It is written to the executive engineer. Your Lordship.
So what can be done in a, you have to file a writ petition. There is no specific relief granted to you, except that representation is to be considered. That's all.
Because only because the non-availability of the service book, which is.
No, correct, but then we can't issue directions in contempt case. That is wrong. Some courts may pass it, but I will not do it because that is wrong. It cannot be done as per the Supreme Court judgment.
And even.
A direction of the court here was that the Accountant General will consider the representation and pass an order. So the Accountant General, Senior Accounts Officer, well, Accountant General passing an order, I don't understand.
And in
much
reply
about
to
it.
that representation, Your Lordship, the executive engineer has also written to the under secretary, Your Lordship.
So you should get a clear direction. You are in a hurry to get an order from the court. Something is okay. Consider his case, then what happens is this. Heard Mr. H. Buragwai, Learned Counsel appearing for the petitioner, also heard Mr. P. Nayak, Learned Counsel appearing for the respondent number.
Both Lordship.
But for the respondents, first up. It appears that in terms of the order dated 4/1/2019 passed by the Learned Single Judge in WPC number 7254 of the 2016, the Senior Accounts Officer in the Office of Accountant General bracket ANE bracket Assam has called for the service book of the petitioner, but the same has not been forwarded by the authorities. Full stop. Mr. You have produced this. Mr. Buragwai has also produced a copy of the communication dated 4/6/2022 issued by the Executive Engineer PWRD Nalbari District Territorial Road Division, Nalbari. Addressed to the Under Secretary to the Government of Assam, reflecting that the service book of the petitioner has already been submitted to the government for meeting the objections raised by the Accountant General Assam. However, despite the same and notwithstanding the request made by the executive engineer to transmit the service book to the office of the Accountant General ANE Assam, no action has been taken in the matter. First up. Unfortunately, the only direction contained in the order dated, unfortunately for the petitioner, the only direction contained in the order dated 4/1/2019 is for the Accountant General ANE Assam to consider the representation submitted by the petitioner within 2 months. There is no direction for forwarding the service book as such. A service book. Although Mr. Buragwai has submitted that some directions be issued in this case, the said prayer cannot be accepted in view of this settled legal position that fresh directions cannot be issued in a contempt case. As such, by granting liberty to the petitioner to approach this court by filing appropriate petition, if so advised, this matter stands closed. You file a petition and have the patience to tell the learned judge what is your grievance and what is the direction you want. In a hurry, if you get an order, this is what will happen.
Item 38.
May I please your lordship? My lord, the petition was appointed as constable under Assam police by DO 3897 dated 13/10/1999. My lord, I think he received several awards, my lord. My lord, while he was posted at Sarvanguri police station Dhubri in the year 1982-1988, he intercepted 2 trucks. My lord, this is a factual fact, my lord, loaded with illegal logs, as well in the year about 1982, and informed the senior Abildar Anganwadi and requested to do the needful for seizure of the aforesaid logs and a registered case. As no action was taken, he also informed the then Deputy Inspector of Police, Mr. Dolo Singh, but he also took no action for reason best known to him. And when the petitioner told that we will inform the higher authority, he took offense and threatened to teach a lesson to the petitioner when he will come back as superintendent of police. Finally, after all that, when the petitioner was posted in the office of the Mankacha Civil Inspector, Mr. Dolesen became superintendent of police and posted at Dhuburi. He called the petitioner to come immediately at Reserve Branch Dhuburi and meet him with WT message. As directed the petitioner, he reported on the appointed day at Reserve Branch Dhuburi at 10 a.m., but Mr. Dolesen was not there. He came to Guwahati where his family was. Then he said, the petitioner waited for the whole day, and in the evening at about 4:30 p.m., he left for quarter.
Mr. Chutia, are you appearing in this case?
Yes,
Ready for disposal?
my lord, otherwise, my lord, we have not received any instruction. I have seen his appeal is dismissed because limitation is, my lord, after 28 years, he come for appeal for dismissal order. Dismissal order 1985, and he come for appeal in 2014. That's why that has been, my lord, rejected.
My lord, during that time,
So,
mental
delay in
disorder,
recess, my lord, the petition is not, has no
Please
merit.
let him finish.
So he delay in recess, my lord. But even now he has failed to, my lord, explain the delay sufficiently. That's why, my lord.
So you don't want to file any affidavit?
My lord, I will have to, lordship, my lord, I will have. We have received a, we have sent a letter, my lord, with 21, my lord, we have received an instruction, my lord.
No, but this is a 2020 matter.
2020 matter, my lord. I will file affidavit because, my lord,
Then we'll fix it for admission after 2 weeks and.
with in the meantime, I-
my lord. All for the record of the case, my lord. It is the factual fact, my lord. It is the factual, my lord. My lord, as he was dismissed from service, he was in mental support. And he challenged the challenged the petitioner. I will teach the lesson. He was dismissed with grass, my lord. Intentionally, my lord. He then tabled so much, tabling so much pilgrimage, Tirthasthan, my lord. After us, some later, he was given medical examination, medical fit, but he was given gradually, my lord, given 28 days quarter card for his alleged period, absence which was an medical card of injury which he refused to undergo. As such, the Departmental procedure number 1080 was initiated against him, and on the basis of vicious inquiry proceeding of the instant, the Superintendent of Police Dhuburi, who took grasp upon the petitioner, as the petitioner intercepted 2 trucks loaded with illegal logs and requested him to appropriate action, and he took no action. The petitioner told him that he will inform about the matter to hierarchy. My lord, as far as I will unsounded my, I appeal before the appellate authority, condition delay, but my case was not. I said, my lord, it is paid before the interference may be before interference of this honorable court.
Sorry?
My lord, record of the case, record of the case, record of the case, call for the record of the case, issue a rule, absolute rule, and let the restaurant authority file affidavit. I will reply in this regard.
All right. You want a rule to be issued? That will delay your case. All right, heard Mr. You are Edas, is it?
He was in the interest of call for record of the case and let the restaurant file affidavit.
You are Mr. Edas.
Yes, my lord.
Heard Mr. Edas, Learned Counsel for the petitioner, also heard Mr. T.C. Chutia, Learned Additional Senior Government Advocate Assam, who prays for 3 weeks further time as last chance to file affidavit, prayer allowed. this writ petition be listed again on 17th of March 2023 as a fixed item for admission. On the next date fixed, the learned Departmental Council to produce the records facilitating disposal of the writ petition at the stage of admission hearing.
Here the issue is regarding payment of arrears salary to the petitioner, in addition to allowance, that is the non-practicing allowance due to the doctor's matter. He has a claim for that. Regarding the arrear payment, some 82 lakhs or has been already sanctioned. It has been forwarded to the treasury. By next week, it will be in his account. After deduction of taxes, of course. Regarding that non-practicing allowance, he has stated that that has not been released to him. On that point, I like to have instruction. 1 week's time, that been given. I will have the instruction on that point. Regarding area salary, that has been already cleared. It is lying with the treasury. By next week, it will be in his account. After deduction of taxes, that may be recorded.
Next week, it will be in an account.
Lordship, may I make my submission? Lordship, in the order of the Honorable Court on 8 March 2019, I was directed to file a representation to the authorities, which I did on 1st of April. And it was received by them on 4th of April. The Honorable Court also directed the opposite party to reply to my representation, to dispose of my representation within 3 months. And that hasn't been done. I have not received any reply to my representation because there are issues other than the area pay and the non-practicing allowance. And those matters have not been taken up by the authorities. I want speaking
interest. Interest.
No, that's it. You give him an answer.
In
That will be an answer. You are a doctor.
Yes, my lord.
Instead of passing a speaking order, we are my lord, after the pendency of the contempt petition, the amount has now been paid. This has been our speaking order that we are going to pay.
All right, Dr. Lashkar, can you wait for another 8-10 days?
Yes, sir.
Let them deposit the money.
Yes, sir.
Then we'll see what is the picture, right? We are putting this matter again on 27th of February as a fixed item and take down. Dr. Basanta Lashkar, the petitioner is present in person. Mr. D. Gogoi, learned counsel appearing for the respondent submits that a sum of rupees 82 lakhs.
82 lakhs, 2,578.
Put the amount.
8,202,570.
Being the what is this? The
Arrear salary.
Arrear salary payable to the petitioner has been sanctioned and the instructions have gone to the treasury. The amount
sanctioned by the health department.
sanctioned
And
by
it
the
is now
health
being
department,
forwarded to the treasury. So by next week, it will be paid.
and it is now being forwarded to the treasury.
Profit.
By next week, the amount will be paid in the account of the petitioner
After deduction of taxes. it will
after
be-
deduction of taxes. Mr. Gogoi submits that as regards the other issues
Lordship.
involved in this proceeding, he be granted 10 days time
Yes.
to obtain instruction.
Lordship.
Prayer allowed?
Lordship,
Yes.
Lordship, the money will not be deposited in 10 days. So
No,
please
no,
give a later date.
no,
Please
no,
give a later.
we have recorded his submission. That's not how court proceedings are. You have patience. It will be deposited. Instead of 27th, we'll have it on first of March.
Lordship.
1st of March. On the request of Mr. Gogoi, let this matter be listed again on 1st of March. But after this assurance, the money is not
It will be
deposited for
paid.
any reason.
Yes, we have.
Your officers are coming in the second half.
It will be paid. Yes.
Money will come on before 1st of March.
Yes. By next.
You
week,
show
it will
us
be
the proof.
deposited.
Yes, then we'll
Okay.
see other things. Yes.
Today in the morning, we have received an affidavit from the respondents. At para 5 of the, this is not on record because today it was filed, therefore. But this affidavit has a speaking order. It seems that a speaking order has been passed on 10/2/2023, but it is not annexed to this affidavit. What if we have to challenge also, we had.
Where is the speaking order?
Lordship,
Speaking order has become a missing order. Huh? Why have you not annexed the speaking order?
We have.
What is the order speaking? He is entitled to know.
Lordship, we have written this in this paragraph, Lordship.
Huh?
Paragraph 5, we have.
No,
mentioned
no,
it,
no, you
Lordship.
give him a copy of the order. Where is that order?
Lordship, we have the order.
Where is it? Give me.
Then also court can also.
Please take your seat. Let me see the order. You have it. Huh?
Yes, Lordship, but it is not in,
It is in your WhatsApp. Then you want my mobile number. How will you give it to me?
Lordship,
How will
I'll
you show
bring
it to the
up.
court?
I'll get it, Lordship.
Huh?
After some time, I can place it, Lordship.
Okay. But you give him a copy.
Lordship, I'll.
All right. Heard Mr. B.P. Boral and counsel for the petitioner, also heard Ms. S. Kemprai
Yes, Lordship.
and counsel appearing for the respondent numbers.
Respondent, both the respondents, Lordship.
Both the respondents who submits that the affidavit filed on behalf of the respondents this morning is not on record. Registry to therefore trace out the affidavit and tag the same with the record of this case. List the matter again after 10 days. In the meantime, Ms. Kemprai to furnish a copy of the speaking order dated
10/2/2023.
2022.
To the petitioner's counsel so as to enable him to obtain instruction.
Objection. Lordship, 41, same.
41 same order. Same
Same
order.
Same order. Next item also same order. But you take out printout, otherwise how will you show it to the judge?
Lordship,
You have to show the order, no?
Lordship.
Hmm.
Objection.
May I please, your lordship? Lordship, on the last occasion, the respondent took time to file affidavit, but that was not filed till today.
Your lordship, a review petition has been filed in this matter, your lordship.
Hmm.
That matter came up on 20th of January.
Hmm.
So it was, it couldn't reach, so next, it was fixed for next after 1 week. So your lordship may allow both the matter to come together.
But this one and the review petition.
Yes, your lordship.
What is the review petition number?
7/2023.
7/2023.
Yes, your lordship.
Miss, your name
R.
please?
Doctor, my lord.
R. Datta, learned counsel is present under the petitioner. Miss
Gogoi.
R. Gogoi, learned counsel, appearing for the respondent submits that a review petition against the order of the court is pending before this court, and therefore both the matters be taken up together. In view of the request made by Ms. Gogoi, let this contempt case be listed along with review petition number 7/2023.
Objection.
Item 43.
Right, not office note says, my lord, the service upon the respondent number 1 is, my lord, awaited. So I may be permitted to, my lord, take, my lord, dusty service upon the respondent number 1.
Contempt case, no dusty service.
Alright.
No. Contempt case.
Then, my lord, fresh notice may be.
You want to take fresh steps?
Yes, will take place.
Achha. Had Mr. M. O. Mandal and counsel for the petitioner peruse the office note dated 2/11/2022. On the request of Mr. Mandal, petitioner is permitted to take fresh steps for service of notice upon the respondents by registered post with the AD. As well
Respondent number
as
1, my lord.
respondent number 1 by registered post with AD as well as usual process. Steps within a week from today.
Obliged.
Item 44. Make Mr. Lordship. The matter needs to be competent appointment, my lord. In this case, my lord, the petitioner's father, my lord, was working in Sugali, my lord, expired on 14/5/2012. Thereafter, on 27/2012, my lord, I applied, my lord. On 28/2014, my lord. The DLC Mala recommended my case, Mala. Ultimately, Mala, the SLC Mala on 3/6/2019, Mala, rejected my case on the ground, Mala, that it had spent its force, Mala. Whereas, Mala, there was clear-cut vacancy, Mala. The DLC had recommended my case within a period of 2 years, Mala. And Mala, the DLC instead, Mala, recommended the case of the private respondent, whose case was rejected by the DLC
on my lord 22/1/2014.
Yes, what do you have to say?
Lordship, the father of the petitioner died in harness in the year 2012. And the SLC has rejected his case in the year 2019. And the petitioner approached this honorable court in the year 2022, after 2-3 years back. So it's a delay of laches, first of all. And secondly, my lord, the rejection of the SLC, my lord, may kindly have a look, page 33 for a moment for the petition. We have filed affidavit also, my lord. The second last paragraph of page 33, my lord.
Page 33.
Yes,
SLC.
second last paragraph from serial number 5, the
Hmm.
petitioner name reflected, may I read from that point.
Yes.
For the Sri Udit Narayan Purkastha, son of so and so, who expired in 2012, so and so, so and so. All the applicant have already spent their force for more than 2 years, and there was no vacancies during that period. Hence, the committee unanimously rejected their prayer in view of the above reasons, lordship. We have the SLC has considered the case of the petitioner in the year 2019. So in that point of time, 2015 OM is taken into consideration. In lordship, may kindly have a look our affidavit. We have annexed the OM, my lord.
Where is your affidavit? It is not on
Affidavit.
record. When did you file it?
That's for 4, my lord. 4.
No. When did you file the affidavit? It is not on record.
We have filed the affidavit on 10/2/23, my lord.
No, then it is not on record. Let the
Copy has been
affidavit.
served on me.
Huh?
They have served the copy on me.
But you don't want us to do anything.
Yes, ma'am, definitely. Madam.
Without the affidavit, how can I?
Lord,
All right,
take the matter some other day.
Yes,
My lord.
with the affidavit. Heard Mr. SP MR Adhikari, and counsel appearing for the petitioner. Also heard Ms. MD Boral and government advocate Assam appearing for the state, who submits that an affidavit on behalf of the respondent number 4 has been filed on 10/2/2023. However, the said affidavit is not on record. The registry to therefore tag the affidavit dated 10/2/2023 with the record of this case and list the matter again after 10 days.
For admission. my lord.
And for admission.
Ma'am.
Yes.
Deeply obliged. Item 45.
Yes, you have been waiting for the whole day. What is the order that is required here? Have you seen the record? What is the order that is required?
As per last order, respondent were directed to file affidavit.
Yes.
Lordship, we have received the instruction, we'll file affidavit.
When will you file?
So Lordship, 2 weeks time maybe given.
Last chance. No further time. What is your name?
B Todi.
B.
Todi. Todi.
Heard Ms. B. Todi, learned counsel appearing for the writ petitioner. Also heard Mr. K. Kumar, learned additional AG Assam appearing for the respondent numbers 1, 2, 3, and 4, who submits that instructions have been received.
Yes.
And the same would be brought on record within a period of 2 weeks from today by serving advance copy upon the petitioner's counsel. In view of the submission made by Mr. Kaur, registry to list this matter again after 3 weeks by tagging the affidavit with the record of this case. It is made clear that no further time will be granted to the respondents for filing affidavit. So something you have got after waiting, huh? You can tell your senior. Yes.
Obliged.
Okay, item 46.
But last hours and record was called for and service report upon the all the respondents are completed. So let it be posted for admission hearing, madam.
Yes.
We will file, we have not filed affidavit, but we will file affidavit. Primary facie, my lord, I have seen, my lord, lordship kindly see page 18. The petitioner has no doubt. The petitioner, she has passed the higher secondary education on 4/3/2022. What's the last quarter? And page 19, page 20 guidelines. advertisement. ACL number 13, a regular school college going student would not be considered for the seat post. Perhaps he is not eligible.
What is the matter, Mr. Mondal?
This is regarding appointment of Anganwadi workers. Now petitioner got first division in the HSLC exam. So advertisement says, criteria says, who is the meritorious candidate in the HSLC exam, his candidate should be considered as a best candidate. But they have choose the candidate which is got the less mark than the petitioner in the HSLC exam.
And who is that respondent number?
Lordship, I am appearing for the private respondent. 5.
So your client's marks in the metric is less than.
Yes, Lordship, that is admitted, but at the time of application, Lordship, he is a regular student. So clause 13 is very specific, Lordship, regular student.
Clause 13 is page.
Advertisement.
Page 18, Lordship.
No.
Page
Page
19,
19, 20.
Page 20.
Last 2 lines, sir.
Clause 13.
So what to do if you are a regular student then?
Now, regular student, it is open school, state open school. That is the not a regular student.
It is under the council, madam.
Page 18, Lordship, that is the mark sheet, Assam Higher Secondary Education Council, page 18, Lordship. Annexure 3. At the bottom, the date is there, Lordship, 4/3/2022. Left side.
Advertisement October.
So in any case, she was a student.
Yes.
Then how can you be a student and a service holder at the same time? This is a government service.
Let them respond, without filing any affidavit. I will respond to it, Let it be posted for admission hearing. Let them file affidavit.
I am saying his old record says, not I am filing affidavit. I will file affidavit.
All right. Heard Mr. M. Mondal and counsel for the petition. Also heard Mr. P.C. Chutia, learned government advocate, additional senior government advocate Assam, appearing for the respondent numbers 1 to 4, who prays for some more time to file affidavit. Ms. R. Chaudhary, learned counsel for the respondent number 5 is present and makes a similar prayer. On the request of learned counsel, who is appearing for 6? None is appeared for respondent number 6. In view of the prayer made by the respondents' counsel, this matter stands adjourned for 4 weeks so as to enable them to file affidavit.
Yes. 6 is deemed to be sub. Developed.
May it please the Lordship. Lordship, as by order dated 10/2/23 of Lavazima Code, Lordship. Service complete, Lordship. Kindly pay this order dated 10/2/23, Lordship.
So you are appearing for?
One only.
And 2, 3, 4, 5, 6.
These are all Brahmaputra Cracker and Polymer Limited, Lordship.
All right, then let them proceed for admission. Heard Ms. M. Nirola, learned counsel appearing for the petitioner. Also heard Ms. B. Sharma, learned CGC appearing for the respondent number 1, perused office note dated 10/2/2023, which goes to show that service of notice upon the respondent numbers 2 to 6 is complete in this case. In view of the above, register to verify whether any counsel has appeared for the remaining respondents and list the matter thereafter for admission by reflecting the name of learned counsel for both the sides in the register.
Item 48.
Yes.
I have, this is a IAS in this case for publishing a newspaper with a number of steps taken were taken earlier.
Paper publication of respondent of
All right,
456.
we'll allow it. Paper publication, which place? In Assam?
Around in all India level, but published from Guwahati in English paper.
All right, heard Mr.
SZB Atlas.
SZB Aklas, learned counsel for the applicant, also heard Ms. B Sharma, learned CGC appearing for the respondent numbers 1, 2, and 3.
1, 2, 3, and 7.
1, 2, 3, and 7. This IA has been filed by the writ petitioner in the connected writ petition, seeking an order for publication or notice of this proceeding in the newspaper for service upon respondent numbers 4, 5, and 6 by substituted method. Full stop. Mr. Aklas submits that despite notices have been sent earlier, service could not be completed on the respondent numbers 4, 5, and 6, as a result of which the writ petition has not proceeded any further. As such, the necessity for service through substituted method. Ms. Sharma, learned CGC, does not have any objection to the prayer is allowed. In view of the above and considering the facts and circumstances of this case, prayer made in this application stand allowed. The petitioner is permitted, the applicant is permitted, applicant stroke writ petitioner is permitted to publish the newspaper, publish the notice of WPC number 1093/2018 in 2 daily newspapers, one in English and one in vernacular Assamese, having
Maybe in Hindi because they are not.
and in Hindi, having wide circulation in the wide circulation in the country, including the state of Assam. Full stop. The publication be made on or before 10th of March 2023 by showing the date of appearance in this case as 3rd April 2023. The third date of appearance in the connected writ petition is 3rd of April 2023. I stands disposal.
Supplementary list for orders, item 51.
What is it, Mr. Kalita?
Lordship, I mean, this, there was a direction to pay some areas of salary within 6 weeks. So it was not paid. Now, this is basically this Assam Small Industrial Development Corporation Limited. So Industries Department was also made party, secretary and commissioner and secretary. So now what has happened here, Lordship, this corporation, the MD corporation has already issued a letter to the petitioner to collect the check. The amount will be paid, Lordship. This has been done yesterday, 16th. That is my instruction, Lordship. That is that I have.
Lordship, I have received the said letter, but the amount contained in the said letter is not as per order of this honorable court.
All right, I heard Mr. S. Burman, learned counsel for the petitioner, Mr. A. Kalita, learned counsel appearing for the respondent number
1 and 2, Lordship.
1 and 2 submit that yesterday, that is, give the date.
Lordship, there is one mistake here. In the party's name, Lordship, that respondent number 1 is fine. Respondent number 2, it is written as Manavendra Pratap Singh. Actually, he should be respondent number 3. And respondent number 2 should be Oinam Saran Kumar Singh. So there is some mistake.
You are appearing for whom?
For respondent 2. So actually, he should be appearing for respondent number 3 because the MD's name has been written wrongly.
Mr. A. Kalita and Mr. P. Das, learned counsel appearing for the respective respondents submit that the director of this Assam Conductors and Tubes Limited, respondent number 3 should be Manavendra Pratap Singh. The director of Assam Tubes Limited has issued a letter dated 16/2/2023 addressed to the petitioner, asking him to come and collect the check. And therefore, the Therefore, steps for compliance of the court order is in an advanced stage. Although Mr. Borman submits that the amount is contrary to the order of this court, yet this matter is being adjourned for 10 days so as to enable the petitioner to accept the check without prejudice to his rights and contentions in this petition. List the matter accordingly. You go and take the check, then we'll see.
I am ready if we accept, receive that as part this honorable court. But the amount which
You go and receive the check.
Yes.
You means your client. Once he receives, encash it, then he has to also issue some checks. Then you come back and we'll see what is the controversy.
Lordship, what has actually happened is that like in the order, it is stated simple interest. But now I am told that he's asking for compound interest and or something.
That we'll see then later on. Yes. You get the money first, otherwise you'll go.
Yes, he's getting the money.
March ending is coming. If you don't take the check now, the money will go.
yes,
You have not understood.
understood.
You don't want the check now. Huh?
On yesterday I have received,
To go and get the check.
but which amount reflect in the letter.
All right, you cancel the order.
No,
Right like this. We'll hear it next, after 6 months, we'll hear it. Whether the amount is
Sorry,
sufficient or not, huh?
Sorry.
No. But Mr. S. Borman, learned counsel for the petitioner, in submits that although he has received the communication dated 16 to 2023 asking him to come and collect the check, yet until it is decided as to whether the amount is in conformity with the sum payable under the court order, his client is reluctant to go and receive the check. Full stop. Mr. A. Kalita and Mr. P. Das, P.P. Das, learned counsel representing the respondent, submits that if the petitioner is reluctant to receive the check, then a check issued in compliance with the court order, then the respondents are the respondents are left with no choice. First, be that as it may, since the petitioner's counsel is insisting on an adjudicatory order in this contempt case, let this matter be listed again in the month of April 2023. Yes. This is how you people are destroying your client's interest. This is the way. The money was ready, you are not taking the money. Let your client know who is creating this problem.
That's it.
Item 32.
May please your lordship. Case personal affair on behalf of PNRD, my lord. My lord, in this case, my lord, PNRD
Mr. Kalita. Mr. Kalita. Call him. You see, can you just hand over the check to the person concerned and don't involve the lawyer? Let him not be involved. Do you have his number or anything?
I don't have the petitioner's
Do
number.
you have it?
My petitioner's phone number is not along with us, my lord, but I can contact him.
Contact him and hand over the check to the client.
Yes.
Don't involve the lawyer. These people, they don't know anything. So and so, change the order. So and so for the so and so. Mr. A. Kalita and Mr. P.P. Dar, learned counsel appearing for the respondent, submit that the check containing the amount payable under the court order has been drawn up and the petitioner has been intimated to come and collect the amount. In view of the above, this matter will be posted again after 10 days so as to enable the petitioner to accept the check, which would, however, be without prejudice to his rights and contentions in the matter.
Check is already prepared, my.
So we'll hand it over to him.
You hand it over directly to the petitioner.
Lots. May I please your lordship. My lord, he may appear on behalf of PNRD, my lord.
My lord, I am not aware of the matter.
Contempt. My lord, relating to pensionary benefit, my lord. Other person in this,
Can you give him a copy?
my lord. My lord, kindly.
Go through this and see what is to be done to comply with this court order. We'll have it after 10 days. Heard Mr. Ennis, learned counsel for the petitioner, also heard Mr. S. Datta, learned standing counsel PNRD Department Assam, who on the request of this court has appeared for the respondents and 10 days time to examine the matter. Prayer allowed. If you don't,
Yes.
if you say that nothing can be done, then we'll issue a warrant.
My
against
lord.
the petitioner.
Obliged.
Highly obliged, sir.
Timing matters, item 12.
May it please your lordship. This matter, your lordship, basically the challenge is with regard to the punishment, the enhancement of the punishment of the petitioner. Your lordship, I'll just go through a little bit of the gist of the matter. A few dates are there. Apart from that, I'll show that as per the rules, they have not followed. That's basically the case. So, your lordship, an FIR was lodged on 10/9/2008, your lordship. I'm not going to read the FIR. An FIR was lodged on 1/9/2008, impleading the petitioner, your lordship. There is at annexure 1, page 16. Some allegations are there. Then on 11/9/2008, it is a long old matter. 2008, he was suspended. Then charge memos were issued in 27/10/2008. Now, your lordship will kindly turn to page 18/6/2009. That is the enquiry. That part, since we are basically with regard to the enquiry, I'll come into that first. So, your lordship will kindly turn to page 25. Page 25. 25. The allegations are here. That's why I'm reading this. Short one. Short notice is issued on 27th of October 2008. A notice has been issued to the undersigned has proposed inquiry against post number so and so, Havildar G.D. Narendra Singh. There are 2 persons. I am for only one. So the specific name is G.D. Narendra Singh. I am for them. And so and so. This inquiry has been proposed against these 2 members of the CRPF due to their negligence to duly carelessness and other offences done by them in spite of being the responsible post member. The set of allegations attached here is detailed annexure 1 and 2. Related documents to establish the allegations of the accused has also been annexed as so and so. And then, your lordship, for so and so is hereby informed that if they themselves do not appear before the inquiry officer or disobey the order of higher authority as per rule, so and so would be. So this is the notice given. The allegation at page 27. There are 3 allegations. All the 3 short allegations, your lordship, page 27. As per rule 1 of CRPF rules, the force number so and so have been found guilty of disobeying and neglecting the orders by not following rules on so and so at so and so hours when they forcefully demanded money from Sri Ranjit Rai Borua, Assistant Engineer of Nalbari Water Resource Department, at his residence and subsequently being arrested by Superintendent of Police Nalbari. Number 2, it has been alleged that being the responsible member of the CRPF, the force is disrespect their duty as per rule so and so of CRPF by disobeying office orders and thus brought bad repute to the institution. And number 3, it is alleged that the so and so has misused their duty being a responsible member of CRPF by violating rule so and so by means of misusing the government vehicle, motorcycle registration number and gypsy registration number so and so. These are the 3 allegations against me. These are the allegations. So after that, your lordship, an inquiry was held. And I'll just go straight away go to the inquiry report that your lordship will find.
There are 2 delinquents.
There are 2. I am for 1. Number 1, the Havildar, Narendra Singh. So only 1 has come before your lordship. And this matter actually was initially filed before the Patna High Court because on the lack of jurisdiction, thereafter it has come back here. So page 43 is the inquiry report. So inquiry was held and this inquiry report, your lordship. I will read the inquiry report with regard to these 3 proofs, specifically these 3. So that your lordship will find starts from page 44. I'll just read the operative part with regard to all the 3 allegations. There were 3 different operative parts. So page 44 starts the departmental inquiry. Then your lordship will straight away turn to page 48. Page 48. Roman 5.
the final report and verdict of the inquiry officer on the allegation. Yes, this is important. Considering all the aspects, the inquiry officer comes to the conclusion that both the accused went to the residence of so-and-so on so-and-so and subsequently got arrested. But the fact that they forcefully demanded money cannot be established. Therefore, the allegation number 1 level against the two accused is partially proved. The first main allegation of demanding money cannot be proved, but it is partially proved on the ground that they went to the residence of Ranjit Borua. That is only. Second allegation, Your Lordship, was decided at page 49, Your Lordship. The paragraph, this is Roman 4. With the help of the statement of witness so-and-so and Nalbari police, the inquiry officer have come to the conclusion that, page 50, first line, page 50, 50. Inquiry officer have come to the conclusion that both the accused went to the house of Ranjit Rai Borua, and while discussing about extortion money, the superintendent of police Nalbari got them red-handed. There, this act has brought bad repute to the CRPF, which is a very disciplined force. Therefore, the allegation of para 2 has been found to be true. So this is found to be true. That means bringing bad repute. The second allegation, bringing bad repute to the organization. And number 3, third, that is at page 51, it starts 52. Page 51, Roman 4, analysis and assessment of the statement of documents and all. Then it is the final report at Roman 5, 52. So, considering all aspects, the inquiry officer.
So ultimately, what is the submission? What is your
So
submission?
there were 3 allegations. Of these 3 allegations, first allegation of demanding money is not proved. Second allegation that I have taken the official vehicle without consent of the officer, that has not been proved. Only allegation that I have brought disrepute to the organization is proved on the ground that I have visited the house of Sri Ranjit Borua. That has been proved. That is the only. On that basis, Your Lordship, I have given a punishment of downgrading 2 increments for 2 years. This was the punishment given by the commandant. I'll just give a gist of them. That punishment, after giving that punishment, the punishment was reviewed and enhanced to Your Lordship to compulsory retirement. It was reviewed to compulsory retirement without following the due procedure. Now, all the procedures, how it will go, that is there in the CRPF Act. Kindly, CRPF Act on the option.
Did they hear you? Did they serve any notice before changing the penalty?
Yes, that was given, but the authority is not correct. That is why I'm just pointing out there are only 2 clauses of the rules which I'll show Your Lordship. That will show that it is not correct. Lordship will straight away go to the CRPF rules 1955 and straight away to rule 27. Rule 27. Now, rule 27, why I'm pointing it out? Because the authorities have been specifically given in this rule 27. Lordship has got that?
Yes.
Now, discipline. 27. Procedure for award of punishments. The punishments shown in item so and so in column below may be inflicted on non-gazetted officers and men of various ranks shown in each of the headings, column so and so to so and so by authorities named below. Such headings under the conditions mentioned, column 7. So here, Your Lordship, my case falls at serial number 3. Reduction in lower stage in the time scale of pay for a specific period. Here the period is 2 years. And being the constable at 6, serial numbers at column 6, constable and enrolled followers. My authority is the commandant.
Will you please repeat it again? You are relying on rule 27.
First 27.
Procedure for award of punishment.
Yes.
Yes. What is the point you are arguing?
That is the point. First point is that I am arguing this on the ground that the authority to give me my punishment
is the commandant.
Hmm.
It is the commandant. So that is why the reduction of to the stage, lower stage of time scale for 2 years can be given to me being a constable by the commandant. So it has been fixed here. That is why I am showing the serial number 3 reduction. Your lordship has seen serial number 3 reduction to the lower stage in time scale by this has to be done at column 6 by the commandant, and at column 7 to be inflicted after formal departmental inquiry. So formal departmental inquiry was done. The punishment was given, this punishment was given number 3, and that too was given by the commandant. So there is no ambiguity in that, no ambiguity in that. So now the issue comes with regard to enhancement. So before I am going into the act, your lordship will kindly see the 27 continues, lordship will go directly to C. 27, there is a B, there is A, B, C. The procedure, lordship has got C. The procedure for conducting a departmental inquiry shall be as follows. Here, your lordship, I have no allegations with regard to any 1, 2, 3, 4, 5, 6, number 6. If the
You are
command
referring to 27 C.
C. First, I have shown 27, that point with regard to the commandant. Again, I am coming to 6. 6 also states that if the commandant has himself held the inquiry, he shall record his finding and pass orders where he has power to do so. If the inquiry has been held by an officer other than the commandant, the officer conducting the inquiry shall forward the report together with the proceedings to the commandant who shall record his findings and pass orders where he has power to do so. So here also there is no ambiguity. The inquiry was done by an officer, not the commandant, by another officer. Then it was forwarded to the commandant, and a copy was also forwarded to the commandant.
So your client has been compulsorily retired.
Now he's compulsory retired. Now what has happened? So the commandant has given me the punishment of 2 times reduction of 2 times scale. That was enhanced by the DIG, but that was enhanced without the authority of the DIG, because there is, per the rules, there is a provision for enhancement of the punishment. That provision has not been done. Notice has been given, but what has happened after the order was passed by the commandant? The DIG suo motu took up the matter. He issued a notice to me that we would like to enhance your punishment. What do you have to reply to that? We have given a reply. Then he enhanced the punishment. Then I went for appeal, and then I went for the normal procedure of review, and ultimately that was upheld by all the higher authority. So the question here lies whether the DIG suo motu, where he does not have the authority, can be done suo motu without an appeal or without the review. How he can come into that? He's not in the picture. The commandant has given me the order. Fine. Now he has done so. Yes, given me a notice. That is not the issue. Now the notice, whether the DIG has the power to do so. That is why neither in the he is the appellate authority. So once I file an appeal, then he take a decision on that. That's a different issue. He has taken a decision before filing the appeal. Once an order was passed, he took the order on his own and then passed the order of enhancement. So that is not correct. Number 1. Number 2, the reviewing authority is the additional director general. So additional director general, there is a clause incorporated in the act itself where it has said the additional director general has the power to enhance. That is there. How this person enhanced it without taking into consideration all these facts? That is my overall case. So that is why I am showing one thing.
What you filed affidavit?
Yes.
Records are there.
So
Mr. Manan will continue with it on Tuesday.
Tuesday.
Yeah. I'll just refresh a little bit on the.
I'll convince you in this case.
No, I have to argue first.
No, he has to argue. Tuesday you are available?
Yes, this Tuesday. I'm available.
I had Mr. Y.S. Manal and counsel for the petitioner, also had Mr. K.K. Parasil, and counsel appearing for the respondent, CGC appearing for the respondents. heard in part, this matter again on Tuesday as a fixed part heard matter.
In fact, on that day, could not today, on that day, I'll produce a judgment. No, that is a judgment of another high court. But the same matter, it's exactly the same, only the dates are different. I'll produce that on the list.
What else? How many? Yes, what is this matter?
Lordship, may I? Lordship, in this case, two small issues are there, Lordship, whether the new amended rule can be relaxed for promoting the petitioner or not, or whether in case it cannot be relaxed, then whether the old rule can be applied in his case, Lordship. Lordship, in this case, petitioner has filed an additional affidavit, Lordship, that is already in record, but my copy was misplaced. He furnished me a copy today itself, Lordship. Lordship, if your Lordship takes up this matter after 1 week, Lordship, it will be convenient for me.
I furnished him, my brother misplaced it. Even then, next week, any date, if possible.
Heard Mr. H.K. Das, learned counsel for the petitioner, also heard Mr. P. Nayak, who submits that the additional affidavit filed by the petitioner in this case was misplaced in his record. And since the copy has been furnished to him today, this matter will be taken up for admission hearing in the next week. Prayer allowed, praise to release the matter in the next week.
May I please for a date?
Next week has only 5 dates. Yes.
Item 28.
May I please?
My lord, the
Is it
petitioner.
for disposal?
Yes,
I won't be able to dispose it today. You choose a date next week. Thursday, next Thursday. Mr. P. Professor and counsel for the petitioner is present. Mr. Chippel, additional senior government is present on the other state. This case again on Thursday, give the date of Thursday as a fixed item for admission hearing. Yes.